I pray for urgent.
You are a lawyer?
Yes. I pray for urgent because the final decree will be heard on 21 of this month. I pray for Tuesday.
देखिए देखिए जस्ट सेमती कहियो
This is the RS of 2013, my lord. I am for the respondent.
Respondent.
Yes.
Okay.
Item 30, my lord. Day before yesterday, I received the counter, my lord.
Item
30, my lord. After 10 days time to find a rejoinder, my lord. I
Item
also taken
30.
consent of the
Item 30. Learned counsel for the petitioner wants to file rejoinder. List this matter on 25th October.
my lord. My interview will be continued, my lord.
Interim order to continue.
Item 19.
Not put any of them. I'm opposite party.
Who's for the petitioner? You have to take consent.
What to do, let you do, but there is nothing here. Your lordship had to take note of it.
All right.
I'm the state, I'm the beneficiary. State is the main opposite party.
Yeah, but somebody has filed it. Somebody is for the petitioner. So let us wait till let it reach.
My lord, item 19. If you may kindly keep it on any day next week.
Next week, as prayed for.
Item
Item
19.
19.
My lord, item 23. I feel also can be taken up on next week. I have informed to Major.
All right, next week, as prayed for.
Public.
My lord, item 19, let the matter reach. Just mention.
Item 19, somebody is mentioning now.
Let the matter reach.
Why?
It was actually posted today for last chance for hearing. There are already matters of
All right, let it reach. Let it reach. Yes.
Supplementary list, item number 1 for judgment.
In the result, the appeal fails and is therefore dismissed. There shall be no order as to cost.
Item number 2 for judgment.
In the result, the appeal succeeds and is therefore allowed. The impugned judgment is hereby set aside. The matter is remitted to the First Appellate Court to hear the appeal RFA number 43/34 of 2005-2007 afresh on merits and to dispose of the same within 4 months from today in accordance with law.
Item number 3 for judgment.
For the foregoing reasons, therefore, this court finds no merit in the writ application, which is therefore dismissed.
Item number 4 for judgment.
For the foregoing reasons, therefore, this court finds no merit in the writ application, which is therefore dismissed.
Item number 5 for judgment.
In the result, the writ applications are allowed. The impugned order dated 17/6/2022 passed by the ADM Kandhamal Phulbani in this case number so-and-so is hereby quashed. The opposite party authorities are directed to issue orders of engagement in favor of the petitioners as early as possible, preferably within 1 month from the date of production of certified copy of this judgment by the petitioners.
Item number 6, press admission.
That's all.
Item number 7. Item number 7, may I please, my lords.
Lords, there are two transfer application. First one is the TRP CRL, my lord, in which I have filed for the husband, my lord, to transfer, and there is another TRPC which was filed by the wife, my lord. It was yesterday, my lord. So, my lord, I pray that this matter may be resolved. So, your lordship may direct the matter to be sent to mediation, my lord.
Yes, what do you say? You
My lord, I have to take instruction because there are two cases in Bhadrak, my lord. One, the divorce case which wife wants to be transferred to Bhadrak from Jajpur, and another GR case is there in Bhadrak. So our prayer is that, my prayer is that the civil case for divorce by the husband should be transferred to Bhadrak for the sake of convenience of the wife, because I am not taking any maintenance.
And she has filed.
If my brother says that
This matter may be settled, my lord.
mediated, I have to take instructions.
Correct.
Let it be.
Is this matter next week? Parties to.
My lord, first matter has to be admitted, my lord.
Not necessarily. Not necessarily. Not necessarily. The counsel for the parties are requested to take instructions from their respective clients as to if the matter can be resolved amicably through the process of mediation.
My
It will
lord,
come next week.
my lord,
Both the matters will come next week.
my lord, may I pray IA to be considered?
It will come next week. So why are you worried?
Item number 8,
Pass over.
item number 9,
Item 9, pass over.
item number 10,
Major lords. And here I am for the wife, my lord. The husband, who is advocate, filed a divorce petition at Berhampur, my lord. The wife is rejected with her parents, my lord.
Okay.
In the state of Cuttack,
All
my
right.
lord.
Notice, stay. Tari date ko. 8th
November.
8th November.
May I please, your lordship? Your lordship, item number 9, your lordship, there are some,
Wait. It has been passed over. You have to wait till the end of the list. Yes.
Item number 11,
May I please, your lordship? My lord, I am filing an IA. How the sub-collector has played foul play with this honorable court, my lord?
ये writ application. Prayer है कौन? Advocate requires the improved order dated service charge 2000 salary and actually complete selection of the post of India.
My lord, on 13/8/2024, this matter was taken up on face admission, and this honorable court has directed is to notice to minor state council to
ये कहूँ तो आस्ते कथा था करियो बोले. If it is not possible, then I will leave the court. I will raise them.
to ascertain regarding my lord competency of the sub-collector to stay the selection process of any Anganwadi.
No, what was this? The matter shall be disposed on the basis of the co-order upon पढ़ुचंती.
My lord, first order 13/8/2024.
Yeah.
Passed by the son.
Sub-collector stay the selection process of mini Anganwadi center while functioning as appellate authority under miscellaneous certificate rules. Yes.
My lord. After knowing this fact, on 16/8/2024, the sub-collector has disposed of the certificate case, my lord, appeal case. Appeal case and directed Tahsildar to cancel my residence certificate.
Yes.
Accordingly, Tahsildar had cancelled and the selection process was continuing. My lord, the date was fixed to today for convening the selection meeting to facilitate the respondent number, opposite party number 6.
No, I don't understand.
And the order was
If the sub-collector has cancelled your
certificate.
residential certificate in an appeal, then you have to challenge it further
No, no.
by filing a writ application.
ମୁଁ ସେଇଟା ମୁଁ ଚ୍ୟାଲେଞ୍ଜ କରିବି ଯେ ମତେ ସାର୍ଟିଫାଇଡ କପିଟା ବି ଦଉନା ଆଜି ଅଛି ସିଲେକ୍ସନ ଟା
ଅଲଗା କଥା.
ଯଦି ସାର୍ଟିଫିକେଟ ମିସ୍
So any selection made shall be avoided by the result of the any challenge that you will make.
Yes, ma'am.
So there's no use keeping the writ petition pending.
Yes.
Isn't it?
ରିପିଟିସନ ପେଣ୍ଡିଂ ରଖିବା ଲାଗି ମୁଁ କହୁନି ଯେ ସେ ଯୋଉ ସେଇଟାକୁ ଆପଣ ଷ୍ଟେ କରିଥିଲେ in the meantime 28
Oh, stay ଥିବା ଭିତରେ ସେ ତାକୁ dispose of କରି ଦେଇଛି.
ଆଜ୍ଞା
How?
କରିକିରି ଏନେ ବର୍ତ୍ତମାନ ତାକୁ ଦେବା
How? Where is that order?
my lord on 28/2024 my lord has stayed the informed order.
When did I pass that order? 28. 28. So when was the order passed by the sub-collector?
My lord on 16/8/2024
16/8.
my lord.
Then
13/8 ରେ instruction ପାଇଁ କହିଲେ instruction supply କଲେନି 16/8 ରେ ସେ dispose of କରିଦେଲେ case
ସେଥିରେ ଆଉ କଣ କରିବା? Before
ଯଦି ଜାଣିଛନ୍ତି ସେ order ଟା ମୋର
no, 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 no,
ସେଥିରେ ସେ
no,
ଲେଖିଛନ୍ତି
no, no, no,
Honorable High Court has
no, no,
passed
no,
order.
no, no. Mere pendency of a writ application does not automatically amount to stay. A positive order of stay was passed on 20th. By the such time, the sub-collector has disposed it of. He may have antedated the order, but there is no proof. How can you say that? So he, rightly or wrongly or whatever, sir, suno. An order has been passed. You have to challenge it. That's all. Before the appropriate forum.
ନାଇଁ ମୁଁ ଏଇଟା ତ ଚ୍ୟାଲେଞ୍ଜ କରିବି ମତେ ସାର୍ଟିଫାଇଡ କପିଟା ବି ଆଜ୍ଞା ମୁଁ ତାଙ୍କ କଣ୍ଡକ୍ଟ ଟା ମୁଁ ଦେଖାଉଛି ମାଲାଫାଇଡ ଇଣ୍ଟେନସନ ଟା ଯେ ଆନେକ୍ସର 8 ରେ ମିସକେସ ରେ ଦେଇଛି ମୁଁ 2 ରୁ ଆପ୍ଲିକେସନ ଦେଲିଣି ମତେ ସାର୍ଟିଫାଇଡ କପି ବି ଦଉନାହାନ୍ତି କିନ୍ତୁ where as they are going on selection process my lord and date was fixed to today.
The selection process will continue, but it will.
ସିଲେକ୍ସନ ଯଦି ତାହାକୁ କରିଦେବେ ପୁଣି ମୁଁ ସାର୍ଟିଫିକେଟ ଅପିଲ ଚ୍ୟାଲେଞ୍ଜ କରିକି ଆସିବି ପ୍ଲସ ଅପିଲ ଫାଇଲ କରିବି
say ଅଟକି ନା at the instance of one person the selection cannot be stopped.
ନାଇଁ ସେଇ ତା ଇନଷ୍ଟାନ୍ସ ରେ ଆଜ୍ଞା ଷ୍ଟପ୍ କରିଦେଲେ ସବ କଲେକ୍ଟର ମିସଲାନିୟସ ସାର୍ଟିଫିକେଟ ଅପିଲ ରେ ସେ ସିଲେକ୍ସନ ଟାକୁ ଷ୍ଟପ୍ କରିଦେଲେ ୱିଦାଉଟ୍ କମ୍ପିଟେନ୍ସି ୱିଦାଉଟ୍ ଜୁଡିସିଏସନ ମାଇନର ଏଇନେ ସିଲେକ୍ସନ ପ୍ରୋସେସ ଟାକୁ ଯଦି ସେ ଦେଇଦେବେ ତାହାକୁ ତାହେଲେ ମୁଁ ସିଲେକ୍ସନ ଏଗେନଷ୍ଟ ଯିବି ଅପିଲ ଯିବି କଲେକ୍ଟରଙ୍କ ପାଖକୁ ଏଡିଏମ ପାଖକୁ.
You do one thing. I'll keep it pending. I'll stay the selection process. You obtain instructions. Learned counsel for the petitioner files an IA in court. After serving copy on the other side, same be registered. By means of this IA, the petitioner seeks stay of the selection process of MAWW,
Madam, many Anganwadi.
mini Anganwadi worker, stay of selection process of mini Anganwadi worker of Koinga, KAINGA, till final disposal of the writ application. So it is further stated that the sub-collector was being, the sub-collector, despite being aware of the order passed by this court on 13/8/2024, directing the State Council to obtain instructions as regards the competence of the sub-collector to stay the selection process of mini Anganwadi center while functioning as appellate authority under the miscellaneous certificate rules, the sub-collector has disposed of the appeal on 16/8/2024 in cancelling the resident certificate granted in favor of the petitioner. Stop. It is alleged by the petitioner that thereafter the sub-collector, also being the chairperson of the selection committee, has fixed the meeting of the selection committee to 13/9/2024, that is today. Stop. It is further submitted that the petitioner applied for grant of certified copy of the order rejecting the resident certificate on 2/9/2024 as evident and has enclosed copy of the counterfoil of his copy application. Yeah, stop.
But that has been received on only 11/9.
Maybe 11/9. So it is submitted that the order passed by the sub-collector is proposed to be challenged by the petitioner before the appropriate forum, and therefore till such time the selection process should be stayed. This court is of the view that while it is open to the petitioner to challenge the order of the sub-collector before the appropriate authority, there is no need to completely stay the selection process indefinitely. Under such circumstances, it is directed that the selection process may continue, but no final order shall be passed without obtaining leave of this court. In the meantime, learned State Council shall file counter affidavit to the writ application. Place this matter on 25th October. Yes.
Yes, sir. I may be given liberty to file an affidavit indicating this order. Aji ଅଛି ତ ଆଜି ସେ କରିଦେବେ ଏ ଅର୍ଡରଟା ନେଇକିରି ବି କିଛି କରିହେବ।
Yeah, selection process will continue.
Already completed, ଖାଲି ରେଜଲ୍ଟଟା ପବ୍ଲିଶ କରିବେ ଆଜ୍ଞା। ମୋର ସେଇ କେସରେ ମୁଁ ଯେହେତୁ ପାଇଯିବି ବୋଲିକି ସେ ଆପ୍ରିହେନ୍ସନ କରିବି being gained over ସେ
So ହେଲାନି ଏଇଟା ଶୁଣନ୍ତୁ ଯେହେତୁ writ application is pending and this order has been passed, so whatever they do it will abide by the result of this writ application. So your right remains protected.
ଆଜି ଯୋଉ ଅର୍ଡରଟା ହେଲା ଏ ଅର୍ଡରଟା by way of affidavit I will intimate the authority.
Learned counsel for the petitioner is permitted to produce a copy of this order before the selection committee. Through an affidavit. Stop. Urgent certified copy be granted in course of the day.
Okay.
Item number 12.
On the last occasion, direction was made. Take instruction regarding what steps they have taken pursuant to the order passed in appeal.
Yes.
Appellate order is at page 31.
No. Last time
Sir,
you were directed to take instruction that the matter was remitted to the selection committee by the ADM on 6/5/2024.
now the sub-collector has written to the CDPO
Yes.
to submit all records.
So the selection committee meeting has to be held afresh.
Yes.
That is what the ADM had directed. So we'll fix a time limit. We'll
Yes.
fix a time limit within
That
4
would be
weeks.
better, yes.
Within 4 weeks. Land State Council has obtained instructions that the selection committee meeting has not been held as yet, as the sub-collector has sought for certain documents from the concerned CDPO. Stop. Since the order of the ADM directing, remitting the matter to the selection committee for fresh consideration was passed on 6/5/2024.
2014 man.
2014 to 2024 age. 6/5/2014, the writ application is disposed of, directing the sub-collector Balesore to act upon such order of the ADM without any further delay and to conclude the process within 4 weeks from today. In the order dated 31/8/2024, the date mentioned in paragraph 2 be corrected as 6/5/2014. Yes.
Item number 13. Item number 13, may I please, ma'am? Lord, in this case, the petitioners have approached this honorable court for a direction to the opposite part number 2. That is the collector and district magistrate of Korandi to complete the process of promotion of the Anganwadi workers that have been selected in the year, that process has begun in the year 2021. Till now, they have not completed the process, as because another woman had filed a writ petition before this honorable court and there was a stay. But by today, the writ petition has been disposed of and the stay has been vacated.
Where is that? What is that writ application number?
Lord, it is under Annexure 2,
Yes.
page 15.
Yes.
Page 15, my lord. You must see the operating portion that is in under page 19, paragraph 6. In such view of the matter, the concerned department is directed to consider the grievance of the petitioners as and when they are eligible as per the qualification and experience.
Yes.
Interim order dated so and so stands vacated. Accordingly, this writ petition is disposed of. Thus, thereafter, we filed a representation before the sub-collector, and according to the representation, while Annexure 3, that is letter dated 7/2/2024, they have again initiated the process of selection on the previous list of the selected persons, the recommended persons. They have initiated the selection process, but till date they have not completed the process. But in the meanwhile, the petitioners are very old and
They say that the Honorable High Court has disposed of the WPC, and hence the selection process is going to start very soon.
yes, ma'am.
So this order has been passed in February. So they'll take a decision. So what is your cause of action? They've already initiated the selection process.
My humble submission is there's a very limited grievance that let it be targeted within a short period of time, because all the petitioners are very old and they are about to retire.
Very old means?
But some must
Very old and chakiri kimte ashanti?
57, they are about to retire. But
57 are very old.
No, my lord, they will not get the financial benefits and all timely. It's late how
The petitioners are all working as Anganwadi workers in different Anganwadi centers of the state. Of the state of Kolahandi? Of Kolahandi district. Their grievance is that the selection process for their selection, for their promotion as Anganwadi supervisor, as lady supervisor, was though initiated in the year 2021, and subsequently by letter dated 7/2/2024 of the DSW of Kalahandi, yet the same has not been finalized as yet. Stop. Considering the limited grievance of the petitioner, the writ application is disposed of, directing the CDPO directing the district social welfare CDPO to party करना पड़ो.
to collector and district.
Directing the collector Kolahandi to issue necessary instructions to the concerned authorities to conclude to complete the selection process within a stipulated time, complete the selection process as early as possible, preferably within a period of 3 months from today.
Item number 14.
Obliged.
Petition is agreed by non-consideration of her case to the post of promotional post of not promotional but observation in the post of accountant come data entry operator. The reason they didn't take a final decision, annexure 1. They said that we seek clarification from the government because she took 4 months extra leave because she delivered twin baby and there are some complications. That was allowed. The government has clarified when annexure 7 directly your lordship come to 84, clarifying saying that since they have not been engaged,
Page annexure कितने?
annexure 84,
No, no,
Page.
17, page 18.
page 84, annexure 17.
Yes.
Government has clarified. Not only clarified, they have made an inquiry. Inquiry suggested that he is eligible to get annexure.
Just let me see
Sir.
this. कहले परा may consider their selection on case to case basis if no further disciplinary action is pending against them.
Sir, तापरे annexure 21 last annexure ता देखो inquiry page 90 सेथरे inquiry करिया पे additional program officer कहले program officer details inquiry करी की
Is eligible to be absorbed as accountant governor.
सब सेथरे अछि
Yes.
एवं सेमाने भी मानुचन जे मोर consideration अछि एवं annexure 1 जोटा हम challenge करछि non consideration करचंती किंतु लेखिचन सेथरे page सर page 19 की टिके खाली काइंड आटा page 19 जोटा challenge करछि
This is prior to issuance of annexure 21.
हां सर एटा आरंभ कल तापरे डेवलपमेंट जोटा सर हेछि
But anyway, but now that annexure 21 has come,
yes
so this is automatically superseded.
हां किंतु से नाही इता अपॉइंटमेंट करि परिबन सिलेक्शन ताकू इंक्वायरी करिया
So he has to take into consideration the inquiry report. That's all. The collector has to take into consideration. Yes, sir.
annexure 17 now annexure
All right.
21
The petitioner is working as Gram Rojagar Sevak. को जगह
Kumpapura Panchayat in the district of Ganjam.
Kumpapada
पंचायत
Gram Panchayat in the district of Ganjam. As per the set key rules, set the rule as per the Odisha accountant cum data entry operator amko rules. So that amar rules rules. Gram Rojagar Sevaks working continuously for more than 5 years and fulfilling other criteria are entitled to be absorbed in the regular post of accountant cum data entry operator. Stuff. The petitioner's case was not considered inter alia on the ground that she had remained on maternity leave unauthorizedly, and there were some cases pending against her.
नहीं सर केस किछ नाही कि अनऑथराइज भी नहीं
But again, that was the either the प्रथम लिखा है annexure 1 रे.
नहीं सर एटार देखिजन पेज 20 की आसन सिलेक्शन कोन पाई रीजन ता पेज 20 रे से लिखिजन जे नो वर्क नो पे विथ आफ्टर कोची 8
Hey, sir, second part लिखंतु खाली लिखंतु जे medical leave हैला. Unauthorized for a long period. Stop. The matter appears to have been inquired into by the APO is kono?
additional program officer
Additional program officer of the concerned block.
जगन्नाथ
After going through all the materials, the inquiry officer has found the petitioner eligible to be absorbed as accountant cum data entry operator in Ganjam district. Stop. The report was submitted on 27/8/2024. Stop. The petitioner's grievance is that despite such favorable report, the petitioner's case has not been considered for absorption. Stop. In view of the limited prayer of the petitioner, the writ application is disposed of, directing the collector Ganjam to consider the case of the petitioner for absorption, taking note of the inquiry report of the APO referred above. A decision in this regard shall be taken within a period of 6 weeks from the date of production of certified copy of this order by the petitioner.
Item number 15, pattern matter.
statute challenges the order of removal by the annex of 17 that is
So that professor who had gone to Malaysia.
Malaysia. And
And yes, yesterday there was it was pending before the chancellor.
pending for the chancellor.
Yes.
And the chancellor directed the university to produce the DP file and directed him to allow him to work. But they have not allowed me to work. Not neither the DP file was produced. The matter in still stops.
My instruction minutes directed to extra minutes, whatever high instruction I received. And I will pass this letter.
Anna.
All these have been produced, including the inquiry report.
I am directed to say that no,
Waited because of the repetition is pending to pursue it, so thereafter they will take it. Till then, the appeal to await.
shall wait till disposal of the writ application. Now I am deciding to wait till disposal of the appeal. Now he has put the buck, passed on the buck to me. So
2000.
Thereafter, my
no, Mr. Panda, there is no use keeping the writ application pending any further.
2014 melons at page 57. But through
Sir, no. Once an appeal is pending, why should this court interfere? Why should this court interfere? You will be losing one forum. Now, if I will close this writ application taking note of this, what will happen is your appeal will be disposed of either way. It may be allowed, it may be rejected. If it is rejected, it will give rise to a fresh cause of action. If you are so aggrieved, I don't know.
Yes.
So that will be unnecessary keeping it pending. The stalemate of each matter.
Within a stipulated time.
That I will say. That I will say.
2014, I got the appeal melons.
No, but now they say, you see, this date, this is 12. All right. But the chancellor has made it clear that he will not take any decision till disposal of the writ application.
सेटा भी हमें सब तक एनक्लोज करके दे जो तब फर्स्ट लेटर रे जो चिट जो प्रोड्यूस करछन तार रिप्लाई.
So this so-called inquiry, this is a fact-finding inquiry. This is no inquiry in the eye of law. This is just a fact-finding inquiry. So on that basis, you cannot remove.
সেটি অপিলে সেটা পেন্ডিং আছে ইনকোয়ারি কথা কোনি সে তিথিটা লাস্ট তিথিরে এডা সব ডকুমেন্ট লা এনক্লোজ করি করি চ্যান্সেলর কা অফিস কো দিয়া
So according to you, no further action has been taken.
Settlement because of the repayment.
So Mr. Panda, I don't think it will help your client. I will not pass any order on it. I will simply say that the petitioner was aggrieved by the order of removal and he has filed an appeal before the dismissed. All right. Heard Sri D.K. Panda, learned counsel for the petitioner. And Sri Dhananda Mahapatra, learned counsel appearing for the Utkal University. In course of hearing, the petitioner, while working as professor of
Yes, sir. Sociology, bracket CAS.
Professor Sociology, bracket CAS in the university was removed from service by order dated 28/9/2011. Stop. He challenged such order he has challenged such order in the present writ application. At the same time, the petitioner also preferred an appeal before the Honorable Chancellor under section statute 304 of the Odisha Universities, first statute 1990. Stop. In course of hearing, Sri Dhananda Mahapatra, learned counsel appearing for the university, you file this, files a copy of, we will take it on record. By way of a memo, you file it. Files copy of a communication dated 7/1/2012, made on behalf of the Honorable Chancellor to the then counsel appearing for the university, specifically indicating therein that the Honorable Chancellor has directed that the appeal petition shall await disposal of the present writ application. Stop. Since the petitioner has already availed of the statutory remedy of appeal, this court finds no justified reason to keep the writ application pending any further, as the grievance of the petitioner can be considered and addressed in the pending appeal by the appellate authority. Stop. In such view of the matter, the writ application is disposed of, directing the Chancellor bracket opposite party number 1 to requesting the Chancellor opposite party number 1 a direction he period, but he is the governor. Let us make a request.
The secretary. Secretary, Chancellor, secretary direction.
नहीं गवर्नर को भी डायरेक्शन इन दी गवर्नर को ही परियो नहीं चांसलर ही परियो इन द कैपेसिटी ऑफ चांसलर ही परियो बट गवर्नर को ही परियो नहीं nevertheless he is the same person. Let's request कर दो कौन हो the dignity of this court will not go down. Yes,
rather it will be.
Yes. कौन लिखी requesting the Chancellor opposite party number 1 to dispose of the appeal petition of the appeal filed by the petitioner, Dr. Balagovinda Babu, as early as possible. Right. As early as possible, preferably within 2 months. 2 months कर दो, within 2 months. Within 3 months from today, after affording opportunity of hearing to all necessary parties, to the petitioner and other necessary parties. Yes. ये 13 वर्ष बेकार पेंडिंग रहे तेरा गोटे मेमो करके फाइल कर दो हैं नहीं गोटे मेमो करके फाइल करते हैं कौन से मेमो कॉपी
मेमो करेगा
यस आइटम 16
The appointment of the Anganwadi worker, my lord. Doubting the residential certificate of the petitioner, the CDQ made an application to the Tahsildar as to verify the residential certificate issued by him. And Tahsildar again has verified the certificate and found it to be genuine. Thereafter also, they have cancelled the interview and not selected any person.
No, where is that order which you are challenging? Annexure.
I'm telling the order at Annexure 5, my lord.
Annexure 5, yes. ଏତଦ୍ୱାରା ଗିନ୍ଦିଲାମାଲ ଗ୍ରାମର
ସର୍ବସାଧାରଣଙ୍କର ଅବଗତି ନିମନ୍ତେ ଜଣାଇ ଦିଆଯାଉଛି ଯେ ନୋଟିସ ନମ୍ବର 587 ତାରିଖ 19/11/2012 ଗିନ୍ଦିଲାମାଲ ଅତିରିକ୍ତ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରର କର୍ମୀ ଚୟନ ପାଇଁ ଆବେଦନ ପତ୍ର ଆହ୍ୱାନ କରାଯାଇଥିଲା କିନ୍ତୁ ଅନିବାର୍ଯ୍ୟ କାରଣବଶତଃ ଉକ୍ତ କେନ୍ଦ୍ରର କର୍ମୀ ଚୟନ କରାଯାଇ ପାରିବ ନାହିଁ ଓ ଉକ୍ତ ବିଜ୍ଞାପନକୁ ବାତିଲ କରାଗଲା ଏହି କେନ୍ଦ୍ର ପାଇଁ କର୍ମୀ ଚୟନ ପାଇଁ ନୂତନ ବିଜ୍ଞାପନ ପ୍ରକାଶ କରି ଆବେଦନ ପତ୍ର ଆହ୍ୱାନ କରାଯାଇଛି.
But Mr. Purohit, it does not mention that mention any reason as to why it was cancelled.
They have given it in the counter itself.
They cannot.
Paragraph 13.
They cannot. Yeah, if you have not mentioned in your notice, how can you say it in your counter? अनिवार्य कारण एठी ऐसे अनिवार्य कारण को एक्सप्लेन करिवे हबने दिस इज आर्बिट्ररी. I have already passed several judgments in this light. I will just cancel it. सीधा कैंसिल कर दो कि तकरो you are apprehending that this may be a reason.
Well, they have given it in the counter also.
That is what I am saying. That is what I am saying.
The inquiry was held.
Inquiry they have held, my lord. They say that I do not belong to the village, but all the records say that I belong to the village. I have given the
What do you say? This cannot sustain. This cannot be sustained in the post. This cannot be sustained because simply this becomes arbitrary.
In the counter, they have only said
The
about
counter, I will not consider it. What
They
ground
have
you have
not
not taken
also
in
given the
the impugn order, you have not said so. Now you will expand the scope and you will
the
improve upon your
reason in
case.
the counter has also not been given.
Sir?
The reason for cancelling is also not given.
No, but there's some doubt has been raised with regard to the residential.
Para 12 and 13 of the counter, my lord.
That the selection committee has not selected. The opposite parties are continuing cancelled.
That the selection committee has not selected anyone to be the Anganwadi worker of Gindlama Detention Center. The opposite party number 3 CDPO Ulunda District Suvanpur accordingly has cancelled the notice number so and so. They have not selected, only doubting the
Residents.
genuineness of the certificate.
But there, where is it mentioned? Where do you have the selection committee proceeding?
My lord, I take your lordship to the counter earlier part, my lord. That the villagers of Gindlama filed objection petition on 10, 12.
Sir, why should we get into that?
Para 8, my lord.
No, why should we get into that? When the notice of cancellation does not say so, and as per the settled position of law, they cannot improve upon that. So why should we get into that? Once we accept that as a reason, then it means yes,
Reason has been assigned.
it means that this court accepts that this particular reason has been assigned. Why should I? Simply that it has been cancelled without assigning any reason. By the way, what the court may observe by recording your submissions, so that it may help you later.
I am interested in the appointment, my lord. Though I was the only candidate there, I have not been.
No, sir, that is what I will say, that whatever this earlier selection has to continue. If there is any reason to cancel it, there must adequate reasons must be cited.
Since 2012.
Yes. The petitioner applied for the post of Anganwadi worker, I applied for engagement as Anganwadi worker of Gindilamal Sub Anganwadi Center in the district of Balangir.
In the district of Sonpur.
In the district of Sonpur, pursuant to, where is that advertisement? Copy of advertisement.
Annexure 1.
The date likha deun.
Annexure 1, page 7 of the.
No, sir, date ta nahi.
Advertising date.
Date ta nahi advertisement.
This is.
The petitioner has approached this court with the following prayer.
Submitted before 4/12/2012.
Acha, how? कौन लिख लिया? The petitioner? Pursuant to advertisement dated 19/11/2012. The selection committee found the petitioner eligible for the post, and accordingly, she was asked to, accordingly, but certain doubts having been raised with regard to her residential status, who is the opposite party number 4? The Tahsildar Ulunda was directed to conduct an inquiry. In course of inquiry, after inquiry, the Tahsildar found the residential certificate of the petitioner to be genuine, and accordingly submitted his report to the sub-collector, who is the opposite party number 3?
Opposite party number 3, the CDPO.
To the CDPO on 4/2/2013. While the petitioner was awaiting receipt of the appointment letter, she was surprised to find that she was surprised to know that by a notification issued on 16/2/2013, the earlier advertisement had been cancelled, apparently for unavoidable reasons. Stop. Counter affidavit has been filed justifying the cancellation of the advertisement. On the ground that the villagers of Gindila Mal filed an objection on 10/12/2012, objecting that the petitioner is not a resident of said village and that she is a resident of Mundo Mahul. Stop. It is, however, admitted in the counter that as per inquiry conducted by the Tahsildar Ulunda, it was found that the residence certificate issued in favor of the petitioner, wide miscase number 4574 of 2012, is genuine and valid. Stop. Further, the selection committee has not selected anyone as Anganwadi worker of the center. Sir, election पर paragraph 12 पर election has not selected anyone. Yeah.
The Honorable High Court had stated the purpose of advertisement of the
এটা এই কেস রে এন্ট্রি বর্ডারটা হইছে কোন লা The petitioner has filed a rejoinder enclosing the voter list of कौन सा Gindla Mal, wherein she is mentioned as a voter. Stop. It is further stated that the survey list prepared by the lady supervisor cannot override the residential certificate issued by the statutory authority, as also the voter list, showing the petitioner to be a resident of the village in question. Heard Sri S.K. Purohit, learned counsel for the petitioner, and Sri A.R. Das, learned AGA for the state. Sri Purohit, assailing the impugned order of cancellation of impugned notification of cancellation of the assailing the impugned notification cancelling the advertisement dated 19/11/2012. Sri Purohit would argue that the same does not mention any reason whatsoever to justify cancellation of the entire selection process. Stop. In any event, the question of residential status of the petitioner no longer being in dispute in view of the report of the Tahsildar Ulunda that the residential certificate issued in her favor is genuine and valid, the cancellation of the selection process cannot be justified by any means. Sri Das, learned AGA, submits that because of complaints submitted by the villagers of कौन से जगह Gindlamal, the selection process could not be taken to its logical conclusion, and there was no other option for the authorities than to cancel the selection process. Without entering into the factual controversy as regards the complaint, the so-called complaint said to have been submitted by the villagers relating to the residential status of the petitioner, this court firstly finds that no specific reason has been cited in the impugned notification for cancellation of the advertisement. It is only mentioned that the cancellation was effected because of unavoidable reasons within inverted comma, which can hardly be treated as a valid reason. Stop. It is the settled position of law that the authorities have the right to cancel a selection process at any stage. But then it is equally well settled that the action of the authorities cannot be arbitrary, but it has to pass the test of reasonableness. The reference in this regard may be had to the oft-quoted judgment of the Constitution Bench of the Supreme Court in the case of Shankar Das versus Union of India, so and so. Stop. From what has been narrated here and before, it is more than evident that the impugned notice cannot be treated as okay. The reason cited in the impugned notice cannot be treated as valid to justify the cancellation of the advertisement. Stop. As regards the stand taken in the counter regarding the so-called complaint submitted by some villagers against the petitioner and her residential status, this court can do no more than to refer to the settled position of law that the authorities cannot be permitted to improve upon their case in their counter by stating something in the counter which they have not stated in the original notification or original document notification. Stop. As has already been discussed here and before, the impugned notice does not whisper a word as regards the ground, as regards the reason cited in the counter for cancelling the advertisement. Stop. The reference in this regard may be had to the judgment of the Supreme Court in the case of Mohinder Singh Gill versus Election Commissioner, so and so. From the foregoing narration of facts and law, this court has no hesitation in holding that the impugned notice cannot be sustained in the eye of law. Stop. Resultantly, the writ application is allowed. The impugned notice dated 16/2/2013 is hereby quashed. The authorities are the concerned authorities. Let us say the sub-collector is not a party, so we will say the CDPO. Yes, Mr. Purohit.
CDPO and the collector.
Collector को party करना थे अपनों.
Collector is a.
Collector is a party member.
अच्छा, so we'll direct the collector. The collector Sonpur is directed to conclude the selection process initiated pursuant to the advertisement dated 19/11/2012 by taking it to its logical conclusion as early as possible, preferably within a period of 2 months from the date of production of certified copy of this order by the petitioner. Be it noted that the impugned notice, the operation of the impugned notice has been stayed as per order dated
15/5/2013.
as per 15/5/2023.
13.
Sorry, 2013. Pass by this code. Yes.
Item number 17.
Hello. This is matter several times it has come
Yes.
on Pilot's board.
Yes.
Regard to that Sikha Sahayak matter. My lords have been pleased to pass several orders calling upon the state to clarify as to whether the persons who have been appointed appeared for physical verification of certificates. If they have not appeared, then the petitioner who has appeared along with others who serial is at serial number 4 out of 5 vacancies should be given appointment. That specific government on affidavit is there in the petition, which has not been answered in the counter. That is how your lordship on 3 consecutive occasions have sought for instruction from the state. But state has failed to give that reply. On the other hand, state is trying to put red herrings saying that he is a OBC person. There is no OBC seat vacancy available in the district. He has availed age relaxation. That is how he is not eligible to be appointed against OBC. That is how a red herring is placed in the whole subject matter. But I will humbly submit if only to combat that situation, your lordship will find that it is simply contrary to the state's own position in the advertisement and stand. The reason being, this is the vacancy position in Balasore district, SCVC is 0. Since you yourself admit in the vacancy position that SCVC is 0, there cannot be a single person who will avail reservation facility for that SCVC vacancy, because SCVC yourself are admitting to be 0. Now, though in my application, that to one more interesting aspect, they are saying on affidavit that I have availed age relaxation. Lordship may kindly see how wrong is the advertisement. Wrong is the statement. The advertisement, Lordship may kindly see page 29. Page 29 of my brief matter. But how wrong is that stand taken by to wriggle out of the problem? Kindly see page 35.
Page 30.
Right, page 30, page 13. 30. Roman 6.
No, you annexer?
No, this is annexure 4 of my petition.
Annexer 4, yes.
Right. Kindly see Roman 6. The maximum age limit. This is the advertisement to which we have responded. The maximum age limit shall be as per guidelines at SICA, that is 35 years for general candidate. With relaxation 5 years exist. And I am 33, 9 months, 9 days as on the date of my application. That your lordship will find from my application. Application is at page 32. Kindly see page 32.
Yes.
My date of birth is 3rd of December 1980 and I am 33 years, 9 months, 9 days. So the stand taken in the affidavit that I am overage and I have availed age relaxation is again.
Yes.
Kindly see that stand, my lord. Page 2 of their affidavit dated 21/8/2024. Correct.
Where is that affidavit? You are supposed to file it again?
They have filed. 21/8 file करते हैं.
I have already filed.
But they have
You
filed.
already filed, dekh le. Scan in.
No, unacceptable.
Yes, it is there. It is there. It is there.
But you see there stand taken simply contrary with the
Which paragraph?
Lord, para 2.
Para 2.
Continue para 3. Lord, I'm so sorry. Para 3.
Advertisement number ito was followed gala.
Yes. The advertisement annexure 4 issued in terms of resolution so and so, which stipulate that minimum age qualification, minimum category of post. Such stipulation allows carrier mark relaxation in favor of the reserve category candidate.
No, Mr. Rathod, there is some confusion. You are reading from this affidavit dated 22/8/2024.
Well, there are 2 affidavits.
Ah.
One affidavit consists of 4 number of annexures, B, C, D, 3 numbers of annexure. Another affidavit only annexure E/4.
Your lordship is probably holding affidavit dated Korea.
No.
Korea भी सकता है, मुझे देखिए.
But there is only annexure D/4. Annexure E/4 तो नहीं इधर. इधर नहीं.
But D/4 अच्छे.
कोथरे छ.
Korea D/4 अच्छे.
कोड लिखा है इसके
Oh,
यो एठी. अच्छा हो. Okay. So here this contains annexure B/4, E/4.
E/4, yes.
So now you wanted me to see which paragraph of this affidavit?
para 3. कोटा सर अपन कोटा धरचंद जाने.
Yeah, see your latest affidavit.
21/8.
हाँ.
21/8. Sir, para 3 zero.
Para 3. Para 3 says that the advertisement number so and so.
Right. The so and so was issued in terms of resolution. With
No. Again, there is some confusion again.
Sir, what confusion पुणे लगे? हैं?
Yes.
এটা more affidavit आपको दे देंगे देखिए.
नहीं, अबर थिबो बोले they had filed a copy.
फोटो कॉपी दे
So ସେଇଟା ଆଉ ଥରେ ଇଏ କରି ଦେଇଛନ୍ତି. ସେଇଟା ଆଉ ଥରେ ସ୍କାନ କରିଛି ତ. ମୁଁ ହାର୍ଡ କପି ଦେଖିବି. ଏଇଟା ବନ୍ଦ କର ମୁଁ କାଲଠୁ ମାନେ ନେକ୍ସଟ ୱିକ୍ ରେ ମୁଁ ହାର୍ଡ କପି ଯିବି ମୋର ଦରକାର ନାହିଁ. They don't understand anything. ନା ଏଥିରେ ନାହିଁ
ମାନେ
କପିଟା ଦେଇଦେବେ
କପିଟା ଦେଇଦେବେ
ମୁଁ ଗୋଟେ ଇଏ ରଖିଦେଇଛି
ଆପଣଙ୍କର କପି
ମୋଟି ଅଛି ମୁଁ ଏଇଟା I mean, excuse that I have mentioned something on the top that may
No, no, that is
my lord will ignore that. You have mentioned the petition case should be allowed.
that is
no, he has just given a citation. He has just given a citation. Anyway,
My lord. That the advertisement annexure 4 dated 11, no, I said in a letter.
no, that's all.
The advertisement annexure 4 dated 11/9.
Yes, yes. This is totally different from what I was looking at.
Acha.
That is totally, so this affidavit is not there scanned at all.
yes, that
Anyway.
is why madam, since this particular stand was not there, that is why madam, we filed once another
Yes, yes,
affidavit on the same day.
All.
Say for nahi dita ଦେଇଛୁ ଆପଣ
The advertisement on annexure 4 so and so which stipulates the minimum educational qualification.
And issued a resolution which stipulates minimum educational qualification with minimum percentage of marks for different category of posts. Such stipulation allows career mark relaxation in favor of reserve category candidates, including SCBC category candidates, whereas no relaxation is available for your category candidates. The petitioner in the present case has not only availed age relaxation, but also has availed relaxed standard of minimum percentage of marks in degree qualification at the time of application. Copy of resolution dated is done. Now kindly see, ma'am. Kindly see their position of vacancy in the advertisement, in their own affidavit, just the previous affidavit which your lordship was seeing, my lord. Kindly see.
It was the
That
previous.
affidavit podiya affidavit apan
Yes, yes.
ସେଇଥିରେ ସେମାନେ vacancy position ବି ଦେଇଛନ୍ତି କୁଆଡେ ପଡେ
Vacancy position, yes.
ଏଇଠି ପରା ଏଇ ଦେଖ ଆଚ୍ଛା ସାର୍ ଏଇଠି ଅଛି page 2 ରେ ଦେଇଛନ୍ତି
Yes.
ACBC ଆଜ୍ଞା ପୁରା zero. When ACBC you are yourself saying that there is no vacancy, no one can be considered. What is the question of availing relaxation? That is number one. Number two, my age is 33 years. In terms of your advertisement, maximum age is 35 years. I am coming well within the slab provided for your category. So the stand taken in the affidavit is completely inconsistent.
Yes.
Lord, now coming to the merits. Kindly see, Lord, I am a person pursuant to the advertisement made an application. Lord. That advertisement is page 29, my lords, may kindly see. Page 29.
Yes.
11/9/14. But there is no dispute that I am a candidate applied pursuant to the advertisement. I have already shown to my lords maximum age is 35 years, at least 30. Just the next page, Lord. Let's can speak over the next page and got it.
Yes.
Now, pursuant to the advertisement, I made an application. Vacancy position is at page 31 in respect of Balesur district. Arts is 226 vacancies in respect of Balesur district.
Yes.
Now, so far as my application is concerned, page 32 is the application. My date of birth, I belong to the category ACBC is provided here. Now, the select list, my merit list, my lords, my kindly see. Page 33.
Yes.
In the merit list, again, they are reiterating here ACBC vacancy is 0. And out of the 5 persons, they are figuring at 1 to 5. Kindly see. My name is also there. I am also in this select list, merit list, serial number 39, page 35. That's got it.
Okay. Congratulations, Mohan.
Sir, this is petitioner.
Yes.
Now, after preparing the merit list, they called everyone for physical verification of the mark sheet, page for documents, page 42. Annexure, sir.
Yes.
The last 4 lines, bottom 4 lines, the verification of original document certificate of the candidates will be held on 5/5/16/7/8 so Balesur. The candidate will have to bring all original certificates along with self-attested photocopies. Now, pursuant to this note letter, I along with 8 persons appeared for physical verification in respect of those post TGT arts post, whatever is concerned. 8 persons appeared for verification. My serial is page serial number 4 among those people. Now, what they have done is they have appointed 5 in respect of those 5 your vacancy, appointed 5 persons, those who have not even appeared for physical verification. That is the sole point. Keeping that in view, your lordship passed orders, specific orders to give produce material before your lordship. Whether kindly see those orders. Order dated 15th of February 23. It is first order 15/2/2023. देढ़ वर्ष satisfy कर पालेनी 15/2/2023 kindly.
Yes.
Lord, order passed by my lords, my lord.
Mr. So-and-so counsel appearing for the petitioner, so-and-so, Balasore, along with all other certificate, it is further allegation that only 8 candidates appeared on the date fixed, among whom petitioner was placed at serial number 4. In view of the marks obtained by him in paragraph 10 and 11 of the petition, this fact has been stated but not replied specifically in the counter affidavit. Then, Lordship, we gave them time to obtain instruction and to submit reply specifically to the averment made under para 10 and 11. Pursuant to this order, they filed an affidavit. They did not reply it. Rather, they wanted to put red herrings, as I have said, on the question of OBC, ACBC, and availing reservation. Completely not an issue involved here. Now, thereafter, again, Your Lordship passed an order giving them time on 7th of May 24. Then a detailed order again was passed. 18th of July 24, order number 6.
Yes.
Here, Your Lordship was pleased to consider it. Even if I am a CBC, keeping in view to the latest law even settled by the Honorable Supreme Court, whichever category he may belong, he will be first considered as the your category. That's no dispute.
That is the law.
So that is the view you have, Your Lordship has been pleased to consider here, 18 July 2024, and also ask them to obtain instruction and come back to my lords with specific instruction about that. Kindly see, man. This court will like to know whether petitioner was considered in the general list of all candidates irrespective of their social category as per merit. Further, this court would also like to know the response of the state to the submission of Mr. Rudd that 5 candidates mentioned in the select list prepared on 6/5/16 under your category, whether physically appeared for document verification or not. They also specified it. Despite this specific order, they did not come the reply in their affidavit that whether they physically appeared or not on the face of my allegation. Today, my lord, my entire averment in the petition goes untraversed, and on that basis, I'll request my lord to dispose of the matter. Lord, considering as your lordship has been pleased to do in other cases of the same advertisement, your lordship has been pleased to consider in the very recent judgment, giving them to give them appointment. This is a case of overage. Different. Actually, is different. But since they were not considered, your lordship directed them to give them engagement. Same advertisement.
I don't think your case will be
No,
covered by
different.
this.
Actually different. I
It
see.
should be different.
Not only your lordship, I am
No,
going to the same advertisement.
no, just to recapitulate, only one more thing I would ask you to say, then I'll close it.
Right.
So there, let us come to that vacancy position.
Right, well,
Or that final selection list.
right.
Where is it? You have just showing. There is
That
in
is at page 33, my lord.
33 of the.
33 of my brief, Annexure 6.
So this is for Balasore.
This is for Balasore, you are 5. I am concerned about you are 5.
These are all overage candidates.
No.
No, ऊपर लिखा है second preference overage candidate. देखो. Including. Okay. Now, that is not in dispute. So you are at serial number 39.
I am at serial number 39. Not I am specific about verification of document which is necessary for the purpose of selection.
Since they had not come, you were there.
Yes. Lordship now got it.
Are there any existing vacancies now?
May I permit you to submit?
No, you will submit definitely, but my question has to be answered because twice I had asked you to take a. I'm sorry. Twice I had asked you to respond to his specific allegation that 5 persons who had not appeared for document verification were selected.
Yes.
Whereas the petitioner, being one of the 8 candidates,
Yes.
was ignored. Why?
My lord, the very reason, my lord, what we have given in our subsequent affidavits, now it has been placed before lordship, my lord, my senior. The petitioner is well aware of that resolution as well as the advertisement. My lord, may I take your lordship to that annexure E/4 for a moment. Annexure E/4.
Yes.
Before placing my case, my lord, lordship may peruse that annexure E/4, the relevant page. It is at, I have actually marked it, my lord. There.
Yes.
The eligibility, my lord, clause number 6, running page 7. The petition is coming under the category 2, my lord. Page note 8, my lord. In order to be eligible to appear in the examination, graduation with at least 50% of mark in the first year bachelor in education, graduation with 50% of mark and 1 year B.Ed special education or higher secondary +2, its equivalent with at least 50% mark, and 4 years BA, B.Ed, BSc, B.Ed, and pass OTET and candidate most of the ODIs may melt up to class 10. Now, provided that relaxation of 5% in minimum qualifying marks in higher secondary +2 or in graduation level, as the case may be, shall be allowed to the candidates belonging to the SC, ST, OBC, SCBC category. Now, may I take your lordship to page number 35 of the read petition? The select list, provisional select list, where the name of the petitioner appears, madam.
Yes. Yes.
Serial number 39, madam.
Hmm.
His category, it has been indicated as SCBC, and the percentage of the mark, my lord. The percent of the mark, grading percentage, it is 49.
52.8 HSC.
HSC, no,
HSC is
केवल
52.
relaxation होची इथिरे ग्रेजुएशन रे और +2 रे
से कथा तो ठीक है
हम मु देखिल ना इथिरे
सेते आपण रेजोल्यूशन देखले ठीक कोठी तो एक्शन
only for the reason that, my lord, though he has not secured 50%, but availing that 5% relaxation, his case could have been considered in the merit list as a SCBC candidate. Had there been a case of the UR category candidate, unless and until he has secured 50% of the mark, that is what, my lord, specific stand in the affidavit, which is not disputed. That is what our specific stand in the subsequent affidavit, that is answer E/4, where we have stated that he has not availed any other relaxation, but most important, my lord, the relaxation in the qualification. And there is no decision to that effect by the Honorable Appeals Court that a person even availing the relaxation in the qualification merit.
What else?
So, it is age or concession in the examination fees. And that too, Jitendra Singh case, subsequently now it has been decided by the Honorable Supreme Court, saying that since that particular decision is based upon the government guideline, which was in force for them to give such type of relaxation, that is why it cannot have an universal application. Now, this is the latest position. So, here a person is not coming under the her consideration under the UR category post because for having the relaxation in the minimum education qualification. So, unless and until there will be a SCBC post, he cannot be accommodated. Now, what he is relying upon, the entire scenario, my lord, it is a fifth preference post. Prior to that, up to fourth preference, on the basis of that 2014 selection, my lord, that was already complete. The vacancy position, what it has been indicated in the merit list, what it has been prepared, it is for the fifth preference, including the overage candidates. That is 300 some odd, my lord. And out of that, the TGT arts is like this, and we have given a detailed chart indicating the number of the post, and SCBC post is not there. Even if the person has appeared and he has attended the verification process, but unless and until he is eligible to hold a particular post and the vacancy is there.
I get your point. I get your point.
My lord, he cannot.
Kindly see page 35, my lord.
Yes.
Kindly see. That I have availed relaxation in graduation, lordship will not find it from this list.
No, it is said, simply say graduation
That is not there.
49.
He reports about the resolution. The advertisement doesn't say anything about the resolution. Kindly see the advertisement.
Yes.
Not everything has to be done in terms of the advertisement.
Yes.
Kindly see the advertisement. Page 29. Kindly see, madam. It is all.
This is not the advertisement, sir. The advertisement to be issued on 12/9/2014.
Engagement of Sikasa Acts 2014-15.
Sir, para number 1, sir.
That's right. Advertisement to be issued on 12/9/2014.
Yes.
Kindly see, madam.
That has not been included.
That is not there. Advertisement is not there. That's okay. But then you will also see this list. Page 35. The submission that was made that I have availed that.
Hey, that is the case. How could he be placed in the draft merit list?
Yes.
My lord, draft merit is, my lord, again, my lord, I'm submitting. This is what your lordship is now referring to, that is with respect to the fifth preference. But his case has not been considered only for the fifth preference. Starting from the first preference up to the fifth preference, my lord, because there are 5 preferences in that particular advertisement. So His case was ruling out, my lord. And by that time, my lord, the SCBC post were there. And his case was, his candidature was considered.
But
As
I
a
am
SCBC
not- How
candidate.
can it be considered? Kindly consider it. They are not replying. The persons who have been appointed, whether appeared in the physical verification. That is what a vital point they are avoiding at any point.
No,
Every
that's all
point.
right, that's all right. But if you are found to be not eligible, if your qualification is less than 50%,
Yes,
then you will not be eligible.
no, that is not the issue. But if, so assuming for a moment, but if you have made provision that in case of certain candidates, you will make a relaxation up to that person. Now you have given that to me. Now that will that debar me from competing against the other candidates? Because SCBC vacancy is 0. Then why did you give me that relaxation? You should have simply rejected my case that I belong to SCBC and I am below 50%.
No, here we come to a point where we have to make a distinction. You see, as an SCBC candidate availing reservation, no, availing relaxation.
Yes.
Insofar as the minimum qualifying marks is concerned,
Yes.
can he be considered as a UR category?
Yes.
That is the
But
question.
can I be considered as your vacancy, not your?
Anyway.
The reason being that also is subject to clarification note. What my learned friend is saying.
Further, before I close it, any further vacancies are available?
In respect of SCBC, may not the information. is
SCBC
not-
is 0. SCBC
Not in Balasore. Any other district?
I cannot say. Because that information and the.
No, because now huge in other cases we have seen huge number of vacancies have been notified for that junior teachers.
More than thousands, man.
Yes, schematic or something.
Yes.
Yes.
Junior teachers might be. Those things are there.
So if this court finds that he has a case,
Yes.
if at all the court finds so and there is no vacancy in Balasore, he can be adjusted anywhere else.
As your lordship pleases.
So when I would like to close it, I thought of closing it today, but if this information is
My lord, as such, my lord, your lord,
Let-
time and again, we have presented it before lordship
so that can be
about
taken.
the existence of the vacancies.
Let
So
my learned
can we
friend come
deny
back.
that?
Let my learned friend come back with that instruction. I will also come back with that relaxation. See what I कहले, movie ticket factual instruction.
No. That point, no. I'm willing to grant you time, Mr. Rata, but the point that you are raising probably is not in your favor.
No, that is the reason let me take instruction.
Because that case which he is referring to, which I was immediately, it came to my
there is no
mind.
dispute about that.
Although
Let
that
me
is
take that factual instruction whether I have been given that 5% relaxation or not.
ସେଇ ଉପରେ ମୁଁ ଲେଖି ଦେଇଥିଲି ସେ ଦିଟା
ସେଇଟା ମୁଁ ତାଠୁ instruction ବି ନେଇଯାଏ.
Okay. Heard further arguments in part. List this matter. I will simply say list this matter next week. I will not refer to anything. Acha, who learns state council shall inform the court as regards the vacancies available in any district,
Any other district.
any other district.
Sir,
Next week, how 27th. All right. List this matter on 27th.
27 ମୁଁ 20 ତାରିଖ ମୁଁ ବି ନାହିଁ.
Yes.
ତାର ବୁଝିଦେବ.
Item number 18.
So, and only one sentence. So for that particular
ସେଟା
affidavit,
ଗୋଟେ କରିକି ତାଙ୍କୁ ଫେରେଇ
ନାଇଁ,
ଦିଅନ୍ତୁ।
ମୋ ପାଖରେ ଏକ୍ସଟ୍ରା ଅଛି ମୁଁ ସେଇଟା ଦେଇଦେବି ମୁଁ
ଚାଲ,
ଭିତରୁ
ଚାଲ, ଦେଇଦେବି।
ଖୋଲିବା ପାଇଁ ମୋତେ ଟାଇମ୍
ସେଟା ଫେରେଇ ଆଉ
ଲାଗିବ
ଗୋଟେ ଦେଇଦିଅ। ଦେଇଦିଅ।
ହଁ।
ତାକୁ ଇଏ
ମୁଁ
କରିଦିଅ।
ଦେଇଦେବି ସାର୍।
ତାକୁ ଗୁଥି ଦିଅ ଯେମିତି ନହେଲେ ସେ ପୁଣି କେମିତି ମୁଁ ବୁଝିପାରୁନି where did this affidavit go? Yes, what is this?
ଏଇ ନାହିଁ।
Said matter report of RDC.
Yes. क्लोज कर दो भाई जी।
हाँ, सर।
अर्थ तो रखते खाली क्लोज कर आओ आर्गुमेंट करो।
नहीं, I am just submitting 2-3 points. Your lordship may only your lordship may come to the report of the RDC operating person.
Yes.
Operating person, my lords.
Huh.
From the above evidence, it can be clearly established that there is indeed a tampering of the original advertisement. From the facts available, it can only be inferred that the word Mojipoda was added by hand sometimes between 13/3/2012 and 14/24/10/2013, and a short signature was added on 24/10/2013. However, the culpability for this tampering could not be established. Miller. Though the ADM in his report dated 24/10/2013 ascribed it to the then BDO who was in charge of the city. This report of the RDC contradicts the documents produced by the government before LRC. The original documents which was produced before LRC clearly said that the advertisement was both for Majipada and Khanna. As it emailed your lordship's order dated, emailed your lordship's order dated on 30/4/2024. The second thing, my lord, here the RDC said that the video might be tampered with. Then your lordship kindly for a moment come to the advertisement. Kindly come to the advertisement. Whether the video is not there. So for the advertisement, your lordship kindly come to the advertisement. For a moment, your lordship.
I've heard this enough.
For a moment. Video. So for the report, when the categorical the ADM said that, sorry, the RDC said that the culpability may be the video, but the advertisement was signed by the CDOP, not the video. Your lordship may say that advertisement at annexer.
But on that, even assuming that he has somehow this particular ascribing of culpability on the video,
Yes,
this particular aspect may be wrong, but the other factual aspect, how can this court interfere?
Then another thing, my lord, kindly come to the advertisement. Just a moment, your lordship. Just a moment, your lordship, kindly come to the advertisement. At page 25 of the last portion of the advertisement, writ petition, page 25.
Yes.
The signed by the Pratima Das, the CDPO, my lord. Here is not video. Then how the artist come to a conclusion that has been done by video?
No, he is referring to the original file. The original file, not this advertisement which you have enclosed. He is referring to the original file.
Original file, your lordship has already verified.
Yes, yes.
Original file, all the original files are signed by the Pratima Das. Your lordship,
I will go through. I will go through.
All the original files are signed by Pratima Das. Video has no role to play.
Yes, yes. I've heard you. I will go through. If anything else, you think.
Then another document I will.
No, you file your return note.
Just go to the file. Go to record. Another document, Miller. My private opposite party reply has filed a counter on dated 23/9/2021.
Yes.
Got it?
Yes.
On that counter and page number, Miller, your lordship may go to page number, Miller. Page number 20. Got it?
Yes.
Here is the advertisement also by the CDP.
Yes.
Then your lordship may say that the mini Angodwadi Kendra Adhinathar Gamma water number of Khannagar and Majipada. See, he annexed the same. I don't annex the same. Then Miller in the next page, 21. This is the important. This is the important. I may permitted to read the 21 page number 21. Got it, Miller?
Yes.
I just. Somunita sa, Etedwara, that is on 13/2010. ଏତଦ୍ୱାରା 78 ଗୋଟି ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ଗ୍ରାମବାସୀଙ୍କ ଅବଗତି ନିମନ୍ତେ ଜଣାଯାଉଛି ମହିଳା ଶିଶୁ ବିକାଶ ବିଭାଗ ନିର୍ଦ୍ଦେଶାନାମା ନମ୍ବର ସଚ୍ ଆଣ୍ଡ ଡେଟେଡ ସଚ୍ ରେଖ ଅନୁଯାୟୀ ଅନୁମୋଦିତ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ପାଇଁ ଅଙ୍ଗନବାଡି କର୍ମୀ ଓ ମିନି ଅଙ୍ଗନବାଡି କର୍ମୀ ପ୍ରାର୍ଥୀମାନଙ୍କ ଠାରୁ ଦରଖାସ୍ତ ଆହ୍ୱାନ କରାଯାଇଛି। ଉକ୍ତ ଦରଖାସ୍ତ ଗୁଡ଼ିକ ଯାଞ୍ଚ କରାଯାଇ ସଠିକ ଥିବା ଅଙ୍ଗନବାଡି କର୍ମୀ ଓ ମିନି ଅଙ୍ଗନବାଡିଙ୍କ ତାଲିକା ଏଥିସହିତ ସଂଲଗ୍ନ କରାଗଲା। ସମ୍ପୃକ୍ତ ତାଲିକାରେ ଥିବା ପ୍ରାର୍ଥିନୀ ମାନଙ୍କର ସ୍ଥାୟୀ ବାସିନ୍ଦା ଶିକ୍ଷାଗତ ଯୋଗ୍ୟତା ଏବଂ ଜାତିଗତ ପ୍ରମାଣ ସମ୍ବନ୍ଧରେ ଯଦି କାହାର କୌଣସି ଅଭିଯୋଗ ଥାଏ ତାହେଲେ ଉକ୍ତ ନୋଟିସ ଜାରି ହେବାର 7 ଦିନ ମଧ୍ୟରେ ସଠିକ ପ୍ରମାଣ ସହ ନିମ୍ନ ସ୍ୱାକ୍ଷରକାରିଣୀଙ୍କ ଦପ୍ତରରେ ଲିଖିତ ଅଭିଯୋଗ ଦାଖଲ କଲେ ସେଗୁଡ଼ିକ ବ୍ଲକ ସ୍ତରୀୟ ଅଙ୍ଗନବାଡି ଚୟନ କମିଟି ଦ୍ୱାରା ତଦନ୍ତ କରାଯାଇ ତାର ସମାଧାନ କରାଯିବ ଏବଂ ତଦନୁଯାୟୀ ବିହିତ ପଦକ୍ଷେପ ଗ୍ରହଣ କରାଯିବ। ଏଠାରେ ସୂଚନା କରାଯାଉ ଯେ ନିର୍ଦ୍ଦିଷ୍ଟ ଦିନ ଗତ ହେବା ପରେ କୌଣସି ଅଭିଯୋଗ ଗ୍ରହଣ କରାହେବ ନାହିଁ। Then Millard, in this my name is there, the private opposite petitioner. She never filed an allegation. She never raised it in voice at that time.
All right. Hearing concluded, judgment is up. Parties may file their note of submissions and memo of citations if any within a week.
Okay.
Yes.
Item number 20.
19 का कौन लगी? 19 का adjourn निकला है।
Modification. Item 20.
Item number 19.
Item 19 who had mention करते हैं? Item 19.
That is the matter, my lord. Your lordship have heard, your lordship recollect. My honored senior Mr. K.P. Mishra was addressing your lordships on
Yes,
several
somebody-
occasions. And he was taking adjournment on the last 3 occasions.
Senior
And your lordship have specifically fixed at his the convenience to today. On the last occasion, your lordship recollect, my lord. Your lordship heard the matter at least once completely from his side, and on another occasion from the side of.
Senior advocate KP Mishra is out of town. Or next week, any day.
My lord, can I pray for Wednesday, my lord? Next.
18 তারিখ
আগে।
Therefore, adjournment is made on behalf of Mr. K.P. Mishra, Learned Senior Counsel, appearing for the opposite party number,
About the petitioner.
He's for the
for the petitioner, sorry, for the petitioner. Place this matter on 18th September. No further adjournment shall be granted.
Hon'Ble.
Okay.
Item number
20,
Item number 20, in order dated 2/9/2024, order number 8, instead of RFA, it has been written FA. That only modification.
order number 29/2024.
Order number 8, in the interim, it is directed that operation of judgment and decree passed by the courts below in CS number 23 of 2009 is correct, and instead of RFA, it has been written FA.
Considering the submissions, the prayer for modification is allowed. In order dated 2/9/2024, the word FAO be corrected as RFA. Hello? That's it.
Item 21.
May I please? Pursuant to special respondent 1 has appeared.
1 to 4 through, all is sufficient.
1 has appeared.
All right, all right.
It's a limitation of the present appeal. IA number 819.
Yes.
Here my, the appeal was filed in time manner. And paragraph 3 I have mentioned, but I could not remove the defect, production of certificate of trial court judgment. There has been some days.
The certified copy of the trial court judgment.
File again.
So that was the defect. Yes, what do you say?
File कर दीजिए.
नहीं, ताको पछाड़िए उसको. हाँ, what is your stand?
My senior is not here.
The notice issued on issued through special messenger on respondent numbers 1 to 4 has been duly served. Respondent number 1 alone has entered appearance. In view of the urgency, the IA 819 of 2024 is an application for condonation of delay pointed out by the SR. It is stated that the appeal was filed within the period of limitation, but because of non-removal of defects, that is non-filing of the certified copy of the decree, the appeal was held to be delayed. It is stated that in the meantime, upon listening to para 5, the appeal was dismissed.
से कौन डिफेक्ट कंप्लायंस में आउ थरे रीफाइलिंग करो तने हम रीफाइलिंग करो
अच्छा हो
डिस्मिस्ड लिखियो बे हम डिफेक्ट कंप्लाय जेतु मासे भीतर करिया कथा एसआर जेतु न करि परले पुन जजमेंट फेरस्तानी आउ थरे सेटलमेंट फाइल.
But in the meantime, the certified copy of the impugned decree has been filed.
Consider again file.
Was obtained and the appeal has been filed. In the process, there has been some delay. The petitioner had earlier filed the appeal without enclosing certified copy of the impugned decree. The stamp reporter therefore pointed out the defect, but the same could not be complied with within the period stipulated. As such, the certified copy of the impugned order was taken back, and the present appeal has been filed again. In the process, there has been some delay. Considering the fact that the appeal was originally filed within the period of limitation, the delay of 49 days. Kete 49. Kete point out korchanti? Delay of 22 days is hereby condoned. What is the other IA?
Rest day of execution case.
Considering the submissions? Admit hai na?
Na, admit here.
Admit kar dabe. Kon?
Here what happened? The person should be deleted. And kindly don't do.
Hello, because of this condoned, the appeal is taken up for admission. Yes.
Kindly come to page 14.
Page?
Where the legal asset defender was. Person should have filed by the plaintiff should have deleted. But then, my lord, after decree of the suit, execution case was filed by the plaintiff. And kindly come to page 19. The execution case was of 2020. My father died in the year 2020. So they issued notice to the appellant in 2022, July 22. So we appeared in the execution case and filed one appeal challenge under section 97 CPC that though there is no dispute which are to determination share, but the commission report is contrary to the preliminary. We filed appeal. And though we challenge the decree final of 2019, so they say that there is 3 years delay. But man, kindly come to their impugned order, page 34. They say that we are not vigilant from 2019 to 26/80/20. We only appeared in the year 2020. My father was there. My father died in 2021. In execution case, we appeared. We appeared in 2020. So there were only, we have 5 medical bills, there is only 10 days delay. 2 grounds is contrary to the materials available in the record. They say that appellants are not vigilant. Second ground is that appellant number 1 submitted medical certificate and stated that he is looking after the case under appellant number 2. The appellant court said why appellant number 2 cannot file appeal if appellant number 1 is ill. So, but explanation in the limitation has not been taken into consideration. Only one ground.
Say whatever. Heard Sri Master Mantel and counsel for the appellant. Peruse the impugned orders. Considering the grounds, considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. Seta take vague hijo. You got into whether the Learned Court below was correct in dismissing the limitation petition filed by the appellants without taking into consideration the grounds cited therein. Notice need not be issued again?
Appeal notice copy.
No.
And do you carry option over?
Yes. Issue notice to respondent numbers 2 to 4 by registered post with returnable within 4 weeks. Requisites be filed within 3 working days. Copy of the appeal memo will be served upon learned counsel appearing for respondent number 1. Notice on the pro forma respondents be dispensed with for the time being. Hello. IA 1038 of 2024. Yes. Further proceeding in execution case number so and so pending before such and such court shall remain stayed till the next date. List this matter on December, January. December I will January. In the week commencing 9th December. Urgent copy be granted.
Item 22.
It's a dispute between the petitioner and opposite party number 5, my lords, created by the opposite party number 3 and 4, as to who is to be appointed as the Sikha. Number of litigations, the opposite party number 5 also filed number of writ applications, I filed number of writ application. Ultimately, my lords have filed a rejoinder.
But who is for the opposite party?
Opposite party, my lords,
Private opposite party.
private opposite party, I don't know who.
Huh?
That may not be required. In the rejoinder I filed, I have stated categorically, given a copy, that in the meantime, the authorities have regularized the service of petitioner, so also the service of opposite party of 5. They are not, just a minute please. ସେଇଟା ଆପଣ କହିବେ ନା ମୁଁ କହିବି କି? I have given a rejoinder. If you agree to that, if you don't have anything, then I will sit down. As a result of which, the opposite petitioner has been taken as a Sikha junior teacher, then as primary school teacher, and has been put regularizing service put to 7th pay scale. I have also stated that that benefit has been extended to the opposite partner of 5. That is why I have given a counter so that the learned friend state can come, because they are the creator of problems. If they have nothing to do, then my lord, it may not take any time.
It will be disposed of as infructuous
Yes.
now.
Well,
If at all that is a fact.
well, is it?
He is the petitioner, he is saying.
I have given you an affidavit and
rejoinder
rejoinder I have given on that is 10th of July 2023.
No, but even ignoring the rejoinder, if we can record his submissions,
Yes.
I can record his submission.
By the can look that the service particulars that has been.
No, but I will refer to your rejoinder and record your submission, end of the matter.
Yes, ma'am. Yes, ma'am.
Sri J.K. Rathal, Learned Senior Counsel, appearing for the petitioner, submits that in the meantime, the petitioner has been granted the desired benefits in as much as he was appointed, he being initially appointed as Sikha became a junior teacher after 3 years, and thereafter as a regular teacher, primary regular teacher will declare regular
Yes,
teacher
regular teacher, yes, ma'am.
after completion of 6 years of continuous service. Stop. Further, he has been granted the career advancement benefits.
No, career.
So
The pay fixation has been made as per 6th pay scale and 7th scale.
Further,
scale of
he has
pay.
been granted the benefits of pay revision as per the 6th and 7th pay commission recommendations. So, therefore, nothing further remains to be adjudicated in the present
Minus
application.
also add. It is also stated same benefit has been given to the opposite partner of 5.
Sri Ratha further submits that similar benefits have been granted in favor of the private opposite party number 5. Therefore, nothing remains to be adjudicated in the writ application, which is disposed of as infructuous.
That's it. How do you want to that has been given. Documents have been given in the rejoinder affidavit. Minors have rejoinder.
The relevant documents have been enclosed to the rejoinder filed by the petitioner on the last occasion. Yes.
Item 24.
Item 24, my lord. Last order dated 16/8/2024. He was directed to State Government to a last chance file an affidavit in order to comply the order dated 3rd July 2024. I have not received the affidavit pursuant to order dated 3/7/2024.
ଆପଣ କେତେ ଜଣ ଅଛନ୍ତି? ଆପଣଙ୍କର ଦେବେ କି?
I have received the affidavit today.
So that,
Closure of SIT, madam.
Grants of time. So,
Here in this case, my lord, the lordship wanted to know on the basis of the averment in para number 15 of our counter. There we had stated that
ideal salary
has been receiving the salary and other things. In that formality it has been written, and that they have stated that no, it is not a fact. Erroneously, that is mistakenly that has been given. And in fact, with effect on the date of closure of the SIT, not a single person has been paid with anything. And whatever it is due, and even after my lord closure of the SIT, when the pay revision was introduced for them, that particular differential salaries and everything, whatever it was due, everything has already been paid to them.
Well,
And
let
so
him
we-
respond to it. Mr. Patnaik?
within a week.
Well, as directed, London State Council files
You are calling it a counter affidavit. Let us call it an affidavit. Files an affidavit. As directed, State Council files an affidavit in court after serving copy on Sri Patnaik Learned Council appearing for the petitioner, comma, who wants some time to respond. Place this matter on?
7 September.
How was that? On 27th September. Mr. Das,
Yes, I am appealing for NCR.
you have nothing to do in this matter.
Nothing to do, but my presence is required to be taken note of.
Huh.
Otherwise, some problem.
Well, you know, Sri Bimbisar Das, Learned Council appearing for the NCRT also requests for some time to go through the affidavit. Tape likhun to list this matter on 27th September. I have suffered as a lawyer, I told you one day.
Yes.
Because my name was not there.
Yes.
The great All India, the great agricultural insurance company of India Limited, they deducted my fees.
That's what they are doing unless.
And that upstart of an officer asked me to file an affidavit. I said, I will not file an affidavit, you do whatever.
Cannot go up to that extent.
Well, you do whatever, sir. Well, you don't pay me a fees.
Yes.
It will not have any impact.
It will be embarrassing to.
Even though at that point of time, fees was very important for a lawyer, struggling lawyer.
Yes. Initial days of our practice.
Yes.
Very much important.
They don't understand. Yes.
Item 25. Yesterday, you heard about that retired junior assistant of Uttal University. For technicality, you have given retirement in the year 2015, now 2024. Last 9 years is not getting any pension.
Yeah, I think I passed an order.
Your
lordship was about to pass an order, but on the documents filed by the state council, and your lordship had asked me to take instruction.
Yes.
That's everything is
So
open.
to meet it from your own resources. दे देबे आपको.
So your lordship may accordingly order that way
हाँ.
on the basis of the document.
आपण खाली गोटे दिन पे टाइम नहीं थे बोली दियो से डॉक्यूमेंट दियो हर दवाई है ना रखिए कहीं
The last page of the ultimate last page, your lordship may say, see, I have underlined.
They shall not be part of annual block grant sanctioned by government under that is between you and the government. Person cannot he is retired since 2015 and his pensionary benefits cannot be locked up indefinitely. Cannot be done. The petitioner has approached this court with the following prayer. The facts, comma, relevant only to decide the present application are that the petitioner was appointed.
Junior assistant.
Was appointed. Sir, more train of thought step or so. If necessary, I ask you, sir, you can, Mr. Mandi, you can say that. More weakness, I'm fluency no asal daki hoboni break he gala
Sorry.
no please don't be sorry Mr. Mahathi. I just the petitioner was appointed as a junior assistant in the university on 1/10/1983 on consolidated wage basis. On his approach to this court in a writ application being OJC number 190 of 1988 and pursuant to order passed therein on 21/3/1990 followed by order dated 12/10/2001 continue. Le continuamos dorkar nahi se to ହେଇଛି So on 10/10/2012 you were order was passed to regularize your services. Yeah. लिख ले नहीं एमपी लिखंतु नहीं आगो प्रथमटा लिखले जो अपॉइंटेड after multiple litigations the petitioner was ultimately regularized the petitioner services were ultimately regularized as per order dated 26/7/2013. 26/7/2013. Stop. On attaining the age of superannuation, the petitioner was permitted to retire from service on 31/10/2015. Stop. Stop. Despite rendering more than 30 years of continuous service, the petitioner was not paid pension in view of on the ground that his case would be considered under the new contributory pension scheme dated 13/7/2006 of the Finance Department. Stop. According to the petitioner, he having been appointed in the year 1983, should be governed under the provisions of the Odisha Pension Rules 1977, and his qualifying service ought to have been counted by taking his entire past service into account. Stop. Moreover, for the fault of the Mr. Achari, please, kindly. For the fault of the opposite party authorities, the petitioner should not be made to suffer, inasmuch as, despite repeated orders passed by this court in different writ applications, as also the Supreme Court, the authorities took as long as 23 years to regularize the services of the petitioner. Stop. Under such circumstances, the petitioner cannot be deprived of his legitimate right to pension under the old pension or under the Odisha pension rules. Stop. The stand of the university is that the matter of pension was referred to the government as the petitioner's emoluments were being met from out of the grant sanctioned by the government. Accordingly, on 10/10/2012, the government and the Department of Higher Education while concurring with the proposal for regularization of the services of 15 employees, including the petitioner, observed that necessary payment of salary and other allowances shall be made to the said employees by the university from its own resources without any financial burden on government in future. It was further stipulated that the salaries/other dues shall not be part of annual block grant sanctioned by government. Stop. During pendency of this writ application, on a request being made by the registrar of the university as per letter dated 9/8/2024, for reconsideration of the matter, the government in Higher Education Department in its communication dated 11/9/2024 reiterated that the salary and other allowances to the petitioner may be paid from the university's own resources without any financial burden on the government. Stop. The letter dated 11/9/2024 is extracted here in below for immediate reference. There are two letters, Mr. Patnaik.
One is to additional government advocate.
দরকার নেই, আমি এইটা করে আপনি ইউনিভার্সিটি যেটা দেখছি সেটা করে দেবো, হ্যাঁ কোট করে দিন। আগে প্রথম টপরে লিখন্তু heard Sri Sanjeev Kumar Mahanti, learned counsel for the petitioner. The state is a party here.
Yes, my
Come
lord.
on. Sri S.N. Patnaik, learned AG for the state, and Sri Tarananda Patnaik, learned counsel appearing for the university. Utkal University. তারপরে যা লেখা হলো, হ্যাঁ পারা। In view of para from the foregoing narration, this court finds that there is nothing left for adjudication of the writ application, in as much as admittedly the petitioner was appointed way back in the year 1983, but his services were regularized on the basis of order dated 10/10/2012 of the government. Hello. Good.
Annexure 5 will be that gives clear picture. Page 2. Annexure 5 of the letter.
Sir. Huh.
That entire period has been written.
The order dated, basing on the government order, the university passed an order on 24/5 to 24/5 though?
7 years.
24/7/2023. Specifically mentioning therein that the service of the petitioner is regularized as junior assistant with effect from 1/10/1983 in the scale of pay, in the prevalent scale of pay. The said order is extracted here and below. In view of the specific order quoted above, the petitioner must be deemed to have been a regular employee of the university from 1/10/1983. Stop. To such extent, therefore, he would be entitled to pension as per the existing rules, as per the rules applicable to such employees, namely the Odisha Pension Rules 1977,
They have
1992,
service pension rule
1992,
My lord.
Odisha Civil Services bracket Pension Rules 1992. Stop. Such being the case, the university obviously cannot take a stand that the financial resources towards salary and other allowances, including pension, are to be borne by the government. Stop. In fact, the government has made it clear that the university can meet this expenditure from its own resources. Stop. Since this is a case concerning a regular employee of the university, he cannot obviously be deprived of his legitimate pensionary dues by the university on the ground that his salary and other emoluments are dependent on grant sanctioned by the government from time to time. Once he becomes, it is needless to mention that once he becomes a regular employee, it is for the university to meet the expenses towards his salary and other allowances. Stop. It is a matter. It is a matter of regret that the petitioner, after rendering more than 3 decades of regular service to the petitioner, retired on superannuation on 30/10/2015. More than 9 years nearly 9 years have passed in the meantime. And yet, he is deprived of his legitimate pension and pensionary benefits. Stop. It is well settled that pension, not being a gratis, cannot be withheld without any justified reason. Stop. This court, after going through the materials available on record, and in particular, the communications between the university authorities and the government, finds no justified reason for the university to have deprived the petitioner from his pensionary benefits. Pension and pensionary benefits. Stop. Para. For the foregoing reasons, therefore, the writ application is allowed. Who will be directed? 1 and 2.
1 and 2.
So how do you treat the entire period of service? लिखिया दरकार नहीं.
No, not necessarily.
अपन निजे से ऑर्डर करछन जे रेगुलराइजेशन 1/10/2023 1923.
Already
The application is hereby allowed. The university authorities are directed to pass necessary orders to sanction and disburse the pension and other pensionary benefits in favor of the petitioner without any further delay, and in any case not later than 2 months. 2 months. 2 months from the date of yes,
may say 1 month. No problem.
within 1 month. If it can be complied with Mr. Patnaik, within 1 month from the date of production of certified copy of this order by the petitioner. No, Mr. Patnaik is very
one clarification may be there, my lord, for better implementation of the order. Pension and other retirement benefits under the OCS pension rule 1990. That may be quoted. Otherwise, that is the real bottleneck in this.
Yes. Lordship has quoted that.
No, no,
but he's right. Let us quote it. कौन अधिकंतु 9/10 है. कौन लिखी?
Directly to pass necessary orders.
ସେଇଟା ପାଇଁ ଅଛି।
As per the provisions of OCS bracket pension rules 1992.
Yes.
Not to interest because 9 years. That was the Lordship express your view that mandamus will be issued and the interest will be imposed.
That
will be the last straw on the camel's back.
No, that will not be in favor of your client, because they will definitely challenge it and go to the higher forum, and again it will be delayed. Ultimately, delayed.
That was the intention of previously your Lordship expressed.
No, I had said that.
That will be a large straw on the camel's back of the university.
Yes.
Item 26.
I'm filing rejoinder today, my lord. So,
let's see, Satvati Lalan Counsel, the petitioner files rejoinder to the counter affidavit in court today. Oh?
Counter.
File for reaching.
Rejoinder preparation.
Acha ho. Undertakes to file rejoinder to the counter of the state in course of the day. List this matter. Let a copy of the rejoinder be served upon State Council. List this matter on 4th October.
Along with my lord, WPC number 21887 of 13. And you Lordship dispose of similar case.
Achha. Along with the WPC number
21887 of 13.
Of 2013. All right.
Item 27.
Balaram, please. Yes, Mr. Joshi.
Yes, my lord. May I please, your lordship? Yeah, the petitioner was appointed as Asha, my lord, for Bornapat Gram Panchayat under city, right? The Komna Panchayat something district of Nuapara in 2006. While continuing as such, lordship kindly come to annexure 2, page 14, my lord. There is group class between member of scheduled caste, scheduled tribes, which leads to death of two persons. Even though I am no way responsible, I was debarred from discharging my duty. Even my children are debarred from attending the schools as well as Hon'Ble center. Then by Annexure 3, page 15, I bring it to the notice of that medical officer CSC Kumna, who is the appointing authority. Annexure 3, page 15, that is 31/7/2017. No action was taken. By Annexure 6, Annexure 4, page 16, I brought it to the notice of the collector Nuapada.
That you were not permitted to
Yes.
work.
You'll also see the guideline governing the field.
No, you were not permitted to work.
Yes, yes.
So that is why you brought it to the
Yes,
notice. Then what happened?
Then Annexure 5, page 17, again I bring it to the notice of the collector. Then Annexure Gornonku nei Masiko Asa Sobha Anutaritil. There also I was not allowed to. Then you also see Annexure 7, page 21.
What is this?
I got information on the RTA. It is issued by the medical officer CSC Kumna in favor of me with reference to application dated 16th March 2009. Till date, no new Asha has been appointed for that village, and existing Asha named Bhanu Maji of adjacent villages discharged duty. My lord, you see Annexure 8, page 22, my lord. That the guideline governing the field of my place it, my lord. Annexure 8, page 22. That process of derecognition of Asha, my lord. The following process will be followed for derecognition of Asha after being identified as non-functional. Identification of non-functional Asha. I have never failed to discharge my duty of my own. Since dispute arose in 2016 between members of scheduled caste, scheduled tribe, I have not been allowed to discharge my duty. I bring it to the notice of the CDMO, to the medical officer under whom I was working, to the collector, but no action was taken. On the contrary, I have not been identification of non-functional Asha. In order to identify a non-functional Asha, the process of identification is to be conducted following guidelines circulated so and so from Mission Directorate NHM. Though the process was undertaken earlier, following above mentioned guideline, the same process must be undertaken once again for identification of non-functional Asha. The proper documents of the process conducted at the field level as mentioned in the guideline must be maintained. Then preparation of final list of non-functional Asha. Then you also see clause 5. Page 23, my lord. Declaration of derecognition. Based on the minutes of the meeting of Asha, who is identified as non-functional, will be finally declared as non-functional Asha. Due to official process would be followed to derecognize her from the position of Asha. A copy of the minutes of the meeting must be available with the concerned GKS, subcenter, and original so-and-so. Notice of derecognition of the non-functional Asha. Then, after receiving the approval from the once a list was prepared, it was approved. The same is sent to the CDMO con district mission director for approval. And after according approval, the same will be intimated to me. Even though I am continuing as since 2006, continued for almost 17 years, almost for 11 years till 2017. And since there is a group class in the village, I have not been allowed to discharge my duty till since 2017, almost 7 years have passed. Neither have been declared non-functional Asha. Not any notice, nothing has been made to me till later.
What is the stand taken by them in the counter?
And you also see last page 23. No Asha must be derecognized without following due process as per guideline, and else the concerned officials at various level will be held responsible. Page
What is the
23 last
stand
paragraph.
taken in the counter?
We have filed a counter way back in the year 2019, my lord. And no rejoinder has been filed in this case. So, my lord, basically the prayer of the petitioner that she should be allowed to discharge her duties. Now, in several paragraphs, in paragraph number 8, 9, 10, while replying to the averments of the petitioner, we have specifically stated that she was never functioning in Asha, and she was not attending there, and she was never discharging the duties there, madam. And the document what she has relied upon, my lord, that we have also stated in our para number 10, that in a meeting of Community Health Center Bhela on 30/11/2018, she was present. But thereafter, my lord, 1 second, she didn't present. She didn't submit anything, and she did not remain present at any point of time. Then a decision was taken. Now, what is the latest position, my lord? As on that date, Annexure C/4 series, a decision was taken to derecognize her. But that before initiation of that particular stage, my lord, she had approached before this honorable. So it is premature, man. Now she is not attending the offices, my lord.
And your client?
Lordship, OC number 3, the CDM is authorized in this
So
case.
let them take a decision.
Yes, but that-
Taking into consideration the
But-
grievance raised by the petitioner that why she could not attend. If she was not attending, why she could not attend?
may I be permitted to read that only one paragraph of our counter, my lord? Only that. Para number 13, my lord. Internal page number 4. That in reply to the averment made in para number 13 of the writ petition, it is only submitted that petitioner has not been declared as non-functional till date.
Yes.
We are admitting, my lord. Rather, only her name is considered under the category of defunct list as per the report submitted by the Asha Sathi Deodora and Asha Sathi Bhela sector. The petitioner has not been derecognized yet, but the process for the derecognition has been initiated as per the
Right.
guideline.
So I'll dispose of directing them to take a decision after taking note of the grievance raised
Yes,
by
my
you.
lord.
Yes.
Why you could not?
Keeping with the guideline governance.
Yes, guidelines are definitely that they cannot.
You'll also see one more thing I would bring to Lordship's notice. You'll also kindly annex it to page 14. The local doctor was also up. You'll also see I placed that.
No, whatever you say
Yes, yes.
before them.
Yes, yes.
You say it before them. No. The petitioner.
The local doctor को medical office पहुंचा है से भी कहले जे
जो में अपन अफेयर करी पाना because of some caste related.
Yes, yes.
The petitioner is working as an Asha in कोउ जगह से रे
সেটা হচ্ছে
Barandapat
Village.
a village under
the
CHC Komna
CSC Kuna in the district of Nuapada.
in the district of Noapada. Having been engaged as having been appointed as such since
2006.
Since 2006. It is stated that because of certain disturbance occurring in the village
In the year 2016.
ରୁହନ୍ତୁ ଟିକେ ଆଜ୍ଞା ଆପଣ ଇଣ୍ଟରଫିୟର କଲେ ବଡ ଅସୁବିଧା ମୁଁ ମୋର ତାକୁ ଦେଖିକି କରୁନି
Yes, yes.
ଯୋଉଠି ଯଦି କିଛି ଭୁଲ ହବ ଆପଣ ମାର୍କ କରିଦେବେ ସରିଲା ପରେ ମତେ କହିବେ ମୁଁ ତାକୁ ଚେଞ୍ଜ କରିଦେବି ଆଉ village in the month of October 2016 resulting in a double murder. The petitioner was not allowed to discharge her duties as Asha in the village. Stop. Sir, अपना रूम सर अपना कोर्ट रूम बाहर को जाई पारंती he brought such fact to the notice of our higher authorities repeatedly, but no action was taken. On the contrary, steps were taken to de-recognize her as Asha. So, according to the petitioner, the provisions for the guidelines for de-recognition of Asha have not been followed. Stop. This court, after hearing the learned counsel for the parties, finds from the counter affidavit filed by the state that steps have been taken to declare the petitioner as non-functional. Steps have been done. That the petitioner has been declared. That no steps have been taken so far to de-recognize the petitioner as Asha. But the process has been initiated as per the guideline. Stop. Such being the factual situation, the writ application is disposed of, directing the
open to collector come.
Directing the collector, chairman, NHM, Nuapada, to take a decision in this regard. strictly in terms of the guidelines stated, and strictly in terms of the operational guidelines for Asha, and after granting opportunity of hearing to the petitioner. So it goes without saying that the collector shall take note of, shall take into consideration the reasons cited by the petitioner for not attending to her duties at the relevant time. A final decision in this regard shall be taken within 1 month,
2 months.
within 2 months, yes, from the date of production of certified copy of this order by the petitioner. Yes.
Item 28.
Your Lordship. Lord, in this case, the present petitioner is challenging the order of disengagement at Annexure 7, wherein she was disengaged as the Asha work, as the Anganwadi worker, because of the fact that the selection procedure that was conducted in selecting her was conducted in an illegal manner. My lord, my humble submission is that before entering into the merit of the writ petition, your lordship may kindly have a glance at the contempt case that was initiated by us. This honorable court
Any order was passed?
Yes, my lord. This honorable court, wide order dated 15/7/2019, in IA number 9565 of 2019, while not being inclined to stay the subsequent notification that was issued, directed that no final result shall be published without the leave of this court. This was the order dated 15/7/2019. My lord, interestingly, on that particular day itself, 15/7/2019, the selection process was being conducted. So, being unable to obtain the certified copy of this honorable court's order, the present petitioner, via an affidavit, intimated this matter to the concerned authorities that such an order has been passed by this honorable court. In spite of such intimation, they proceeded in declaring the final result. They declared one of the candidate to be selected, and subsequently they have also paid her a salary for a period of 1 year. I have attached that, my lord. May kindly have a glance.
Who's appearing for the private opposite party?
I'm for the intervener. I was the selected candidate.
Okay. Your intervention has been allowed?
No, my lordship, on last occasion opined that after hearing the main petition, lordship will take care of the intervention.
I think we should allow the intervention.
As your lordship.
Because rightly, wrongly, that order has been passed and she has been selected. She has a say in the matter now. No, what do you say? Yes. IA 4037 of 2023. This is an application for intervention filed by one Janani Pradhan, who was appointed as an Anganwadi worker after disengagement of the petitioner. Since the intervener is likely to be affected by any order that may be passed in the writ application, this court feels that she is a necessary party. Stop. The IA is therefore allowed. The intervener is impleted as opposite party number?
My lord,
5.
Opposite party number 3 in the contempt.
No, 8. I mean, we are not.
My lord, 5.
Opposite party number 6 in the writ application. Consolidated cost title be filed in the filed within a week. Let a copy of the writ application be served upon learned counsel for the intervener, opposite party number 6, who may file. No, you need not file counter. Let us see how. List this matter.
25th October.
25th October.
Good.
Item 29.
I will file the gender after.
But only one submission. Raghunath Dikshit.
Yes.
Lordship might come to the prayer. I think I have a doubt on my mind, my lord, that is why. My lord, the petitioner is a regular employee. He has been assigned with certain duties. And this is a matter relating to incorporating something in his LPC. When he has been transferred from one station to another. I think, my lord, that is the case. So whether it will be within your
Not
lordship's
transmitting the
assignment-
quantum of money towards LPC during 23 to till date as well without transmitting the full and final payment on PITA program held in Ete and
Yeah,
adjusted and
government servant purely case data. So I think, my lord, it will be not within your lordship's assignment. That is what, my lord, I am saying.
You're right. You're absolutely right. So see PITA program is a welfare scheme for the but this is not a
LPC रे जेतले पठाई जिसे LPC रे से amount को indicate कर दीजिए. So this will be placed
Let this matter before the assigned bench.
assignment.
Yes.
Item 31.
Pass over. 35 change about.
Sir. Item 32.
Sorry, but the item number 32.
My lord, this matter may kindly be taken next to
We can.
Senior is out of station in Delhi. On behalf of Siddharth Mishra.
List this matter on 27 September as paid. By the, you are for the petitioner?
Yes, your lord.
For the petitioner, yes.
I am for the petitioner in item number 32.
32, you are for the opposite party?
Petition, my lord. Pushpalata Sethi.
Pushpalata Sethi.
32 ଟା ସତ୍ୟନାରାୟଣ କଲ.
No,
sir,
Pushpalata
ସେଇଟା
Sethi.
ଧରିଛନ୍ତି ବୋଧେ.
Out of the weekly list,
Weekly list sir.
yes,
ଠିକ ଅଛି ଆପଣ ଠିକ.
for the petitioner, ହେଲା?
Obliged, my lord.
Kindly be pardoned, my lord. Item 31. Item 31, my lord. I have received the copy of the counter from a learned senior. I'll file a rejoinder, my lord.
You file, you need not, you don't require any order for that. Yes, item 33.
27?
Yeah, 31.
Pass over it.
Oh, item 31, so remove only arrow matter only.
Nice.
All right. Learned counsel for the petitioner wants to file rejoinder. And learned counsel appearing for the opposite party number 5 wants to file counter. List this matter in the week commencing. No, by week nahi, on
8th November.
8th November.
Good.
Yes.
Item 33.
This will take time.
After lunch.
After lunch. All. After lunch, देखिए.
So, counsel for the petitioner draws the attention of this court to the document enclosed as annexure A by 4 to the counter filed by the opposite party number 3 and 4, wherein 4 posts have been kept reserved for the physically handicapped candidate in the following manner, my lord.
OH1, HI1, and vision impaired 2. My lord, this is in relation to clause 2 arts are against 143 total vacancies. My lord, further refers to the averment in the counter affidavit under paragraph 10, wherein rejection of the candidature of the petitioner has been sought to be justified on the ground that one vacancy physically handicapped hearing impaired category has already been filled up. Then so and so further submits that the petitioner does not belong to hearing impaired category but vision impaired category, of which 2 vacancies have been shown in the document at annexure A/4. My lord, State Council shall take instruction as regards to availability of vacancies in the vision impaired category and if the petitioner could be appointed against the same. So, my lord, on inquiry by the director Odisha State WESEPA, it was typological mistake. Se mane admit koruchandi, my lord. Mu deli page 20 re jo vision impaired page 20 my jo certificate issued by the district medical board. My lord, seta hoji VA visual acuity. Then my lord, ezotropia or ezophoria. Ejo VA it is a case of visual acuity. Mu eita hi deithili. It is accepted. Tapore my lord, the director inquiry kale page 46. Se director pore I got the hope to get the engagement. Page 46, my lord.
Yes.
Tankar observation da paragraph 8. And whereas it is ascertained from the report of DPC SS Balangir that the petitioner applied for the post of Shikha Sahaka under clause 2 PH category in Balangiri district as his fourth preparation church during the year 14-15, and his candidature was not considered due to non-available vacancies under clause 2 arts category. Since all 43 and 1 PH HI vacancies of SS on a clause 2 category in Balangiri district has already been filled up by the candidates under first second preference, hence the presentation, my lord. या reply अनुसार, my lord, is annexure A/4 जोटा को पछर देले letter part the after the order of the Hon'Ble court total vacancies and category wise सेइथरे रखिले my lord जो RPWD act अनुसार आमे पाया कथा 4% किंतु जहां बिले 3 देइछन 3 रे my lord last orthopedical handicapped 1 hearing impaired 1 and vision impaired 2. Totally, lordship has previously rightly marked out. Je, I belong to vision impaired. ତେଣୁ ଆମ ଦୁଇରୁ କାହାକୁ ସେ ଦେଇନାହାନ୍ତି ତାଙ୍କର ଭ୍ୟାକେନ୍ସି ଅନୁସାରେ ଏଇ ଗୋଟିଏକୁ ଫିଲ୍ଅପ୍ କରିଛନ୍ତି as per order of the Hon'Ble court ଏଇ ଯୋଉ hearing impaired ଜିତେନ୍ଦ୍ର ମିଶ୍ର he has been engaged in respect of hearing impaired କିନ୍ତୁ I belong to vision impaired ବୋଲେ ମୁଁ ଯେତେବେଳେ ଦେଲି to further inquiry with director my lord ସେଇଟାକୁ page annexure 8 page 34 ସେଇଟା ସେ ପୁଲ୍ ଲେଖି ଦେଇଛନ୍ତି hearing impaired କିନ୍ତୁ hearing impaired ମୁଁ ନୁହଁ ମୁଁ ଏଇଟାକୁ ମୁଁ ସେପଟେ report was called for simple mistake.
Matter is very simple. His application does not mention that he applied under the HI category, but under VA category it should have been VI, but he says vision acuity or something like that. So he has his candidature has been rejected, considering him to be
impaired.
Hearing.
So we'll send it back.
That would be better because
Simply send it back
my
to-
last instruction is also with regard to hearing impaired.
That is wrong.
ସେ ମାନେ ସେ ଏଇ ଲର୍ଡସିପ୍ସ ଅର୍ଡରଟାକୁ ସେ କୋର୍ଟ କଲେ ଏଇଟା ଇଣ୍ଟରପ୍ରିଟ କରି କହିଦେଲେ ଯୋଉଟା କି କରି ଆଉ ଡାଇରେକ୍ଟଲି କମ୍ପ୍ଲେଣ୍ଟ
They have considered
I
his
will-
case under hearing impaired, that is the difficulty.
The petitioner was an applicant for Shikha Sahayak, citing Balangir as his fourth preference district. He applied, he being a physically disabled candidate, had applied along with the disability certificate issued by the medical board of Baleswar, wherein his disability is mentioned as VA, V capital A.
ସେଇଟା ମୁଁ
Which-
ମେଡିକାଲ ଟର୍ମିନୋଲୋଜି ଆଣିଲି
ରୁହନ୍ତୁ ଟିକେ ଆଜ୍ଞା ଟିକେ ଆପଣ ଟିକେ ୱେଟ୍ କରନ୍ତୁ ଆଜ୍ଞା ମଝିରେ କୁହନ୍ତୁନି ମୁଁ ଯଦି ଦରକାର ପଡ଼ିବ ମାଗିବିନି ଆପଣଙ୍କୁ ଆଜ୍ଞା
ସାର୍ ସାର୍
ଡୋଣ୍ଟ ବ୍ରେକ୍ ମାଇ ଫ୍ଲୋ
ସାର୍
I have understood your matter. କଣ ଲେଖିଲୁ?
Sir, he applied to being a physically disabled candidate had applied along with a disability certificate issued by the medical board of Balanced wherein the disability as mentioned as VA.
Is mentioned as VA. Stop. Learned counsel for the petitioner submits that VA stands for visual acuity.
equity ACUITY.
ACUITY. In other words, it is nothing but a case of vision impairment. Vision impairment. EIMPAIRMENT. The candidature of the petitioner was rejected. He approached this court earlier, and being directed, the matter was reconsidered by the state project director, OSEPA. In the order dated 4/1/2021, the candidature of the petitioner was rejected. The claim of the petitioner was rejected on the ground that there are no vacancies for +2 arts category, since all 143 posts and one PH bracket HI vacancy in the said district had already been filled up. Similar stand has been taken in the counter affidavit. However, from the category-wise vacancy details enclosed to the counter affidavit as annexure A/4, it is seen that there are 2 vacancies available under the PH bracket VI quota, VI category. After hearing learned counsel for the parties and on going through the materials on record, particularly the copy of the application submitted by the petitioner, bracket enclosed as annexure 4 series, it is evident that the petitioner has been considered to be an applicant under the PH bracket HI category, even though he had applied for VI category. Stop. This appears to be a factual error committed by the authorities at the relevant time, as also reflected in the impugned order. Stop. In such view of the matter, no fruitful purpose would be served by keeping the writ application pending. Stop. Which is therefore disposed of, directing. Kahaku direction over?
P director 2.
Directing the project director OPEPA, bracket opposite party number 2, to reconsider the matter afresh by taking note of the application form along with the disability certificates submitted by the petitioner at the relevant time. Stop. A decision in this regard shall be taken within 1 month from the date of production of certified copy of this order by the petitioner. Stop. It goes without saying that opportunity of hearing shall be granted to the petitioner, who may substantiate his contentions by further filing opportunity of hearing to the petitioner. Yes, that's all right.
Your lordship referred to the counter affidavit, and further your lordship may also mention about the latest instruction of August 2024 from the district education officer to that effect. Hearing impact.
Such fact has been justified in the counter affidavit. Further, in the written instructions obtained by the State Council from
District education officer.
District Education Officer also, it has been mentioned that the petitioner had applied under the HI category, which is contrary to the records. Stop. Then appropriate jagah rakh do. Yes.
Item 34.
May. The petitioner is selected Anganwadi worker. The opposite party member filed appeal. Appeal was allowed on the ground that the petitioner does not belong to the scheduled tribe category. Well, also can see page 15 for a moment. The last one. I may read it first.
The judgment was cited.
Yes, yes.
Both parties were directed to address the court on their issue decided. Yes.
Sir,
You have not gone through their judgment?
no. In fact, this was allotted to my learned friend, Mr. Patnaik. He was called in other court, he has
Okay.
left.
All right.
So
I would
Monday,
let-
Monday,
Kya bhi kare?
Tuesday, you will also make call.
Next week. Oh. All right. As requested by London State Council, is this matter on 27th September?
Item
The interim order there.
Interim order to continue.
35.
Item 35, there was a mention in the morning. Since you were not there, you want some time?
Because the counsel for the respondent wanted.
That is why I kept it. So, since you were not there, I did not allow them. Is this matter
4th October.
on 4th October, as paid for by London Council for the opposite party? Yes.
Item 36.
May I please your lordship? Item 36, there is no instruction regarding this matter.
No instruction disposed of.
Item 37.
Oblige your lordship.
None appears disposed of.
Item 38.
Discussion the results
Right. Is this matter 2 weeks after?
continue.
Interim order what date?
25th October.
Huh?
25th October.
25th October. Interim order to continue.
39.
Last lordship directed to file an affidavit regarding pendency of the case. And that para. Para 4 of my affidavit, my lord.
Yes.
2 GR cases are pending.
At Kamakhanagar.
Pardon?
At Kamakhanagar.
Yes.
Now you have filed this case for transfer from which place to which place?
Kamakhanagar to Talcher. And Superman Lawrence friend was submitting that for interim international. And he has filed the decree of divorce. I have filed an IA in that case for pendant agreements. 62. By the IA number 62 of 2023.
You have yourself filed these criminal cases?
But affairs have been lost.
They are now committed. One of them is committed to the Court of Sessions.
Yes.
The other also Court of Sessions. Both are now.
Yes.
So since you have filed these 2 cases at Kamakhanagar, now this 125 you have filed it at Talcher.
Well, now I am residing with my father, my lord. So when the necessary occurs, I will only have to depose my evidence, nothing more than that, my lord.
শ্বশুর ঘরটা হচ্ছে সেই তুমসিংহার কামাখ্যানগর
No, no, you want which case to be transferred?
আর মানে ম্যাট কেসটা ম্যাট কেস নম্বর 36 of
That is 125.
no
No, 13-1.
divorce filed by the husband.
So where has it been, where is it pending? Kamakhanagar.
Yes.
Now, all the proceedings are at Kamakhanagar.
No, I have filed 125 proceeding at Talcher. That's why both will be hard together.
Yes.
May Lordship kindly have a glance at Lordship paragraph 3 and 4.
Yes.
Lordship, on the same date, they have filed two separate case proceedings at different places. One at Kamakhanagar and other one at Talcher on the same date.
Yes.
On 6th of October 2023, they have filed that section 24 petition of Hindu Marriage Act against me. And on the same date, they have filed another petition at Talcher of section 125 of CRBC. And she is appearing in this proceeding at Kamakhanagar under section 24 of Hindu Marriage Act. She is appearing there.
You have not mentioned about this? This 24
That is-
petition?
I have mentioned, madam.
They are mentioned as an IA. You know,
No, that is. I have not filed separate proceeding. Madam, in my case, madam, madam, para page 3 of my affidavit, so far as the mat case number 63 of 22.
No, no, since you have already, Mr. Raguru, since you have already filed a petition, IA at Kamakhanagar yourself.
That at that time that divorce proceeding was pending for Kamakhanagar, so I have to file in that divorce proceeding. Separate proceeding I have not filed, madam. I have filed the IA in mat case, madam. After receipt of the notice from the court, madam. And I appeared there. It is separate proceeding. See, mat case I had to file good.
but
Most important thing is that, madam, I have two children, two sons. Thereafter, he married another lady and also he had
No.
one
Lordship,
daughter.
No. That is not true.
That's why I have filed the FIR, madam. Can I have a
No. These criminal cases which are pending at Kamakhanagar, they are on a different footing altogether. So there, she is not required to attend every day.
Yes, madam.
She is just the informant. You are the accused. You can always seek exemption by taking recourse to 317 or 205 as the case may be. But it will allow the transfer.
Pardon you, Lordship. Transfer.
Yes.
Lordship, but the dates of that IA.
No.
different.
No. I've taken note of it. I will allow it. the
And
transfer.
Lordship, kindly have a kindly take a note of the distance also. She has to.
Where
travel
Kamakhanagar to
24
Talcher?
kilometers.
Kamakhanagar to Talcher.
Yeah, 48 kilometers होगी, but मत्ते डुबुरी रू सेटा more than 90 kilometers, 95 kilometers होगी.
So you have filed the case at Kamakhanagar.
Yes, your lordship.
So
That on that सेटा मत्ते आगे होगी 58 kilometers.
no, as compared to the relative inconvenience between you and your former wife, so that which is which will be caused to the wife will be more relevant for the purpose of transfer. It is always the convenience of the lady which has to be seen.
Yes, your lordship. Absolutely, but
As directed, the parties have filed affidavit. I have filed the details of the different cases pending between them before different courts. As it appears, two criminal cases are pending at Kamakhanagar against the opposite party, whereas another proceeding under section 125 of CRPC is pending before the learned SDGM Talcher, being filed by the petitioner wife. Stop. Prayer for transfer has been made of MAT case number 36 of 2023, which is filed by the opposite party for divorce at Kamakhanagar. it is stated that the petitioner, being a lady with two small children, it will be difficult on her part to travel from Talcher to Kamakanagar to attend the court on the dates of posting of the case. Stuff. The learned counsel appearing for the opposite party has opposed the prayer for transfer by submitting that the petitioner wife has herself filed an interlocutory application in the divorce proceeding claiming maintenance under section 24 of the Hindu Marriage Act. After considering the submissions and particularly taking note of the relative inconvenience of the parties, this court is of the view that the petitioner, it would be more inconvenient for the petitioner if the case is allowed to continue at Kamakanagar, particularly when a proceeding under section 125 is pending at Talcher. In such view of the matter, the transfer application is allowed. Virtual mode by yes.
One thing, जो आईएएस की फाइल करछंती तर हियरिंग स्टेज पे आसलेनी और सेटा सब डिफरेंट डेट्स रे हेजी नॉट दैट कि सेही मैट केस रो जो डेट्स अछि सेही डेट रे
किछ असुविधा नहीं कोन हला सेतिर कोन हला हाउ डज इट मैटर यस
Item 40,
permitted to withdraw
item 41.
My lord, in this sub item, my lord and friend has just filed this.
My lord, this morning I was having talk with my brother that a discussion is going on between the parties for amicable settlement. In the last occasion, your lordship was pleased to send both the parties to the mediation center for amicable settlement.
जाइतला mediation को
जाइतला केउझर को जाइतला
तो सेठी फेल हो गला
सेठी फेल है नहीं सेठी ताकू मिसलीड करूछंती
No,
पार्टी की
no, that is wrong. My lord, kindly go through it now.
ना
Counsel କରିବାନି court ରେ.
ना ना ମୁଁ ମଧ୍ୟ କିଛି ଲୁଚଉନି. There are two petitions. One, I am for the husband. I filed an application for dissolution of marriage in the family court at Kendrapada on the ground of cruelty and desertion. After having received the notice, my learned friend filed her application for transfer from the court of the learned judge family court Kendrapada to the learned judge family court Keunjhar. Thereafter, my wife filed an application for maintenance in Keunjhar. Being aggrieved by that petition, I filed an application with a prayer to transfer that petition for maintenance from that court to this court on the ground that both the matters shall be had here in Kendrapada, my lord. Thereafter, on my prayer, your lordship was pleased to send both the cases to the Keunjhar, both the parties for amicable settlement, my lord. That failed.
Yeah, but now you say that there is some talk going on.
Husband is present here, my lord. Husband is present.
That's all right. But there is some talk of compromise going on.
My lord, I have given proposal to my friend. I have given proposal.
All right.
It may be accepted or rejected.
In course of hearing, it is stated by learned counsel for both parties that despite failure of the mediation earlier, talks are going on for amicable resolution of the dispute between the parties.
Proposed by the husband to me.
Yes, talks is going on. List this matter on 8th November. Yes.
Item 42.
I'm for the opposite party. No, I'm seeking for 2 weeks time to file the counter mail. Why
Any chance of settlement?
No, that cancellation proceeding due to non-cooperation by the present petitioner, that cancellation proceeding is dropped.
All right.
So list this matter on
5th October.
on 25th October, as paid for by learned counsel for the opposite party. Yes.
Interim.
Interim order to continue.
Today I have made several telephonic calls, but DP Behera se nije कहले जे हॉस्पिटलाइज ହେଇଛନ୍ତି ତାଙ୍କ ଜୁନିୟର କାହାକୁ ପଠଉଛନ୍ତି ରିସିଭ କରିବା ପାଇଁ ବଟ୍ ତାପରେ ସେ ପଠେଇ ନାହାନ୍ତି ତେଣୁ କପି has not been served yet. Today I am ready with the copy. ସେ ଯେତେ ଥର ଫୋନ କରୁଛନ୍ତି ଲାଷ୍ଟଲି କହିଲେ ଯେ ସେ ହସ୍ପିଟାଲ
is detected cancer malord and
that is why
TM. So
ସେ ହସ୍ପିଟାଲ ଅଛନ୍ତି ତେଣୁ
He can accept.
yes,
He has power in this case.
I'm not.
The copy of the transfer application is served on on learned counsel for the opposite party in court. List this matter on 4th October.
5th ରେ ଅଛି ଆଉ ଗୋଟେ ଡେଟ୍ ପରେ
ତାପରକୁ କରିଦେବୁ
25th October.
25th October.
ଓକେ
Item 44. The last order may be perused.
Yes.
Where I was directed to get instruction. But if I may submit fairly as an officer of the court.
Just a minute.
Number 5 minutes.
Whether any application for setting aside the ex parte order has been filed by before the court.
But to that effect, if I may submit fairly, Your Lordship, the petitioner's local counsel not cooperating with. So my humble submission, subject to Your Lordship's acceptance, is that it may be referred to the mediation.
No.
Because there are 4 cases pending before the.
It's always open to you to have conciliation, but since you are the petitioner, you have been set ex parte
Yes.
in the court below. So you must take steps to, I mean,
My humble submission to that effect, Your Lordship, a minor child is also involved, for whose custody the present petitioner has filed a guardian petition. The same is reflected in para 3 of the transfer petition. So my submission is all of it will be finalized if both the parties are referred to the mediation.
yes, what do you say?
My lord, she is filing one case after another. In the meantime, 125 TB Act, this present case, and that guardianship
I've
miscase.
disclosed all of it in the transfer petition.
So, and in this case, my lord, already from my side, 3 witnesses already meeting.
Hearing is started.
Expectation 3, ତାପରେ ସେମାନେ ଆସିକି High Court ରେ next date ରେ ଇଏ କଲେ, it is
No,
taken.
that order, whether that ex parte order has been, if that ex parte order has not been set aside, it means you are no longer a party to the proceeding. Why should it be transferred?
Yes, Your Lordship.
So I will reject it.
That I humbly concede.
Look,
But Your Lordship,
in the order dated 23/8/2024, the word by occurring in the second last sentence of paragraph 5 be corrected as before. Learned counsel for the petitioner is unable to say whether any application for setting aside the ex parte order has been filed by the petitioner in the court below. Stop. In such view of the matter, this court finds no reason to direct transfer of the proceeding as paid for. The transfer application, therefore, dismissed.
if my lord permitted, in the circumstance, if the said order is set aside, at least she may be permitted to appear through VC in that case. If it is.
No, in case order kari. You are not a party anymore. You have been set ex parte. So how can that order be passed? You seek
The permission of the
yes,
learned
yes.
son.
that
Much obliged. Item 45.
May I see? The afternoon from family judge.
who is appearing for the other side. There are many cases. In Dita cases, there are 2 cases.
Yes, sir.
Who is appearing?
Appearing TRPC 161.
161. Nobody is appearing for the other side. Learned counsel for the petitioner is present. None appears for the opposite party on repeated calls.
list this matter next week. Okay. On 27th September. Yes.
Interim order.
Interim order to continue.
46.
May I please, Your Lordship? Let transfer the case matter from Learned Judge, Family Judge Baleshwar to Learned Judge Panel Court, Bhubaneswar, my lord. Here, my lord, the Learned Judge, so far as the Learned Judge Bhubaneswar is concerned, my lord, the two proceedings. are-
Last time it was said that, last time or some time before that, it was said that some talks of compromise is
Yes,
going.
I've already plus the sitting together, my lord, including me as well as the JR advocate also, but it was not been settled, my lord. There is no likely to be settled, my lord.
Yeah, man, I can send it to mediation if you want.
No, Miller's mediation is not required, Miller, because already both the family persons are settled. Miller in Miller's the circuit house, a long time, for a long time, 2-3 hours, talking is going on, but there is no result, Miller. And
Yes.
here is Miller, two proceedings are pending, 125 CRPC and also domestic violence proceedings in Bhubaneswar, Miller. And they have also appeared in this case, Miller, the 125 is concerned, that already appeared before the said one.
Yes.
Your Lordship, after getting notice of such a proceeding, the present petitioner, present opposite parties has filed another two proceedings against us. Those are pending in Bhubaneswar, Your Lordship.
She wants it to, you want it to be
in-
transferred to Baleshwar.
Bhubaneswar.
Bhubaneswar.
Yes.
And you are also saying,
No, Your Lordship, I am a resident of Balasore. We have filed it in Balasore and they want it to be transferred to Bhubaneswar, Your Lordship.
yes.
But after getting notice of this section, petition under section 9, Your Lordship, they have filed two more cases against us. And the talks of compromise, Your Lordship, that only couldn't materialize only due to the quantum of alimony.
Whatever. You have not decided, whatever may have been the reason, but this court will have nothing to say. I'll allow the transfer. Yes. Heard? Transfer allowed. Yes.
Item 47.
I'm sorry, I may be.
Item 43, interim order is there.
Interim order to continue.
43.
Same to.
Yes.
Sorry.
See, three interim order.
41 interim order is there.
Yes.
Item 8.
Item 47.
Lordship, this can have to issue notice, probably.
Nobody has appeared.
Nobody. No, no, yeah.
Notice देखिए.
The Wi-Fi.
Which confirms the service of notice. No counsel has appeared. Sri B.S. Das, learned counsel for the petitioner, is present. None appears for the opposite party. On the previous occasion also there was no appearance, for which the matter was adjourned to today. Since there is no appearance, the transfer application is taken up for hearing. And a court की transfer चाहूँ
Culture हो गया on
allow कर दूँ. Allowed.
diploma. Item 48.
48. Let extension. Four months further time is allowed to the trial court to dispose of the matter.
49.
May I please? May I please, Mr. May I permit to place this matter on behalf of Ms. Wadhwani? Oh, bless. Lordship, they are filing for application of extension of interim bail, Your Lordship. Your Lordship has been seized to allow the period of 2 months on dated 10/7/2024. And the said period is will up to Your Lordship 18/9/2024, Your Lordship. Now the petitioner, Your Lordship, is suffering various diseases, Your Lordship. Now I have annexed the medical documents, Your Lordship. So may I pray, Your Lordship, kindly extend more time on Your Lordship. Because of Your Lordship.
Considering the submissions, the prayer for extension of interim bail stands rejected.
May I pray one thing?
Yes, Mr. Mahapatra.
She can take it next week, Miss Hota will
She ଆସିଲେ କଣ ହବ?
I say କହୁଥିଲେ ଟିକେ how do you?
22/9/2022 ରୁ ଚାଲିଛି interim bail. Last 2 years.
For a moment, Lord, say kindly consider severe diabetes 429 and cholesterol also.
এই room ভিতরে 80% ଲୋକଙ୍କ diabetic ଥିଲେ, including the judge.
In life dangerous, your Lord say. In life dangerous.
I'm not impressed at all. ହବନି, see life
That's why Your Lordship
I have granted enough liberty to this man.
Wanted to
No, 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 no.
Your Lordship, I pray.
No, I have passed the order.
So kindly.
Go to the Supreme Court.
ନା ନାଇଁ
ହବ ନାହିଁ, ହବ ନାହିଁ।
ସେଇଟା ଦେଇଥିଲେ
No, no, no.
ନାହିଁ
ହବ ନାହିଁ, ହବ ନାହିଁ।
ଟିକେ ଥାଉ ସିଏ ଆସିଯାଆନ୍ତୁ ତାହେଲେ ମୁଁ ଏଇଟା ଆକ୍ଚୁଆଲି ଆଡଜର୍ନମେଣ୍ଟ କରୁଥିଲି କିନ୍ତୁ
ହବ ନାହିଁ। Yes, item 50.
ଥାଉ Your
No, 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 item 50.
Lordship. Your
No, no,
Lordship,
this is an extension of interim bail. 18th
ସେ-
ରେ ରହିଲା।
ହଁ ସିଏ 18 ଅଛି ସେ 17 କୁ ଥାଉ ସିଏ ଆସୁ
All right, Monday କୁ କରିଦିଅ. Please this matter on Monday.
ମଣ୍ଡେ ଟା ଛୁଟି ଅଛି Tuesday
Monday ତ
ଆଜ୍ଞା
ମାନେ Tuesday 17th.
ହଁ
Yes.
ହାଇ ଲୋ କ୍ଲାସ
Item 50. Lordship may see the last one.
Yes, you are required to take instruction from the jail superintendent. Because he said that he wanted to withdraw the bail application.
I have taken.
He wants to withdraw?
No, man. Tapara paste.
This is a petition. Akash Gupta, that is Dushman Sahu. He wants to engage somebody else.
Can do, but I had given that judgment, Your Lordship,
Nee, what judgment?
that
That he cannot make allegations.
no, he cannot directly file seeking transfer of law. He has to take NOC from the petition. That is,
That, yes, yes.
if that portion is protected, no, that has not.
Yes.
Last petition, it is
as
there in
directed.
file.
As directed,
Your
London State
Lordship,
Council.
see this chart.
No, last time I had seen it.
Yes.
As directed, London State Council has obtained instructions from the senior superintendent of Circle Jail, Barampur. A prisoner's petition has been enclosed to the letter of the jail authority, indicating that the petitioner wants to engage another lawyer to conduct his bail application. If such is the case, it is for the petitioner to obtain no objection of his previous counsel and engage any other lawyer that he may so decide. Is this matter 2 weeks per karo? On 4th October.
Item 51.
Wait, please, Your Lordship.
Yes.
First, my lord, we see the last order on 4/9.
Yes, yes.
First on 4/9.
Oh, so there was a direction to the court below.
My lord.
Yeah. The
In between, my lord, my instruction, his case has been completed. It was reserved for judgment. But
no, 313 has been done and it is kept for defense evidence. That I will record your submission.
it was my instruction yesterday evening was it was posted for judgment, and the judge who has heard the Lord and additional solicitors who has heard the case, he has been transferred, for which his judgment could not be delivered.
Somebody else will come and hey, but the transfer ही नहीं लिखा बारी ये तो मैंने से workout ही थोड़ा है किसी transfer ही चाहिए
I don't know but when the instruction has come.
11/9/2024
Correct?
11/9 मैंने 2-3 दिन तोड़ा कथा
313 ହେଇଯାଇଛି election.
election 313 है कि defense evidence को रोजी 17 तारीख को
17 को 17 तो ही नहीं है मेरी।
ये 17 ही नहीं but सीधे सीधे 11 नौ रहे
11 ରେ.
हाँ as directed Leonard court below has
ସେ ଅନୁସାରେ adjourn କର.
Leonard court below has submitted a report stating that
18 Jan.
the matter is posted to the trial is posted to 17th of this month for defense evidence after conclusion of recording of the statement of the accused persons under section 313 of CRPC. In such view of the matter, list this case on नहीं तापर करो
ଅକ୍ଟୋବରରେ କରିବ.
अक्टोबर करो नहीं तापर करो vacation पूर्व गोटे डेट करो तापर vacation करो 4th October the interim bail granted to the petitioner shall continue till the next date.
Item 52.
None appears 1 week after.
Item 53.
adjourn kindly taken on next week.
Next week तो हबो नहीं
27th.
Placed. Item 54.
ये last. बाबा ये last है. अच्छा. Yes.
May I please, madam? Remember, petitioner inside custody manner 1/5/2021. BLAPL number 75557 of 2023. In that case, my lord, 3 occasion.
You have come to the court for the 5th time.
This is the 5th round.
Brown sugar, कितने 400 kgs? 400 grams rather.
3 times it has been targeted. 8/8/2023, 4 month has been given time. There
Brown sugar है किच्छा बोल.
Trial is going on, man.
young boy of 23 minutes.
जितने जाएगा brown sugar है किच्छा बोल.
3.5 वर्ष रहिलाଣି custody रे.
हाँ.
Antecedent नहीं कितने entry bail नहीं.
चाहिए ना.
रहिलाଣି पिल्ला तार total antecedent नहीं.
हाँ बोल.
And seizure rate सबटा very important chapter में लो. Seizure rate तार signature नहीं. Which is a very important thing by which petitioner may.
यार अपन trial खोला सब है अपन.
से ट्रायल टाइम सरुने पर 4 थर टाइम में
कौन करे
लॉर्डशिप में काइंडली सी 25/1/2024 ऑन रिक्वेस्ट this is not direction of the court on request of the London trial court it has been 4 month time has been given then on 1/5/24 again 4 month time has been given so till that my lord only 10 witnesses
the court below is directed to submit a report regarding the status of the trial along with explanation as to why the trial has not concluded despite repeated orders passed by this court to expedite its conclusion. List this matter.
October, sir.
Huh?
4th October.
On 4th October. This order will be communicated to the court below 4th, 5th.
Item 55.
The present petitioner has been apprehended on 16/7/2021. Against 3 persons, allegation is there, including 1 person, the owner of the vehicle, that is the confessional statement, who has created all these things. Petitioner is the occupant. The owner of the vehicle, that is the confessional statement of the court case, he has been granted bail. Even though my lord, your lordship granted interim bail, I have surrendered in right time. I have never misutilized in liberty any manner.
Because you are a very good man, law-abiding citizen, and who completely adherent to the completely adherent to the constitutional philosophy and jurisprudence of this country, isn't it? Yes, the court appreciates your affinity towards that constitutional values.
Just borderline case. Your lordship, I am inside the custody.
Borderline में अपन जानते हैं जाओ.
40 kg.
140 kg. कितने दिन रोले?
Royal 16/7/2021. Your lordship, I can see.
Fourth
I have
round.
been.
4th round.
4th round. You have not articulated single item of evidence.
सेटा कौन?
16/7/2021. That is the FIR. That's just copy of the statement of FIR.
आमोद है ना? आमोद है ना? अच्छा.
Prashant Pradhan alias Buddha, he has been granted bail. Against whom confessional statement, that is there. I have to concede to that extent. Occupant, 3 person, and till today, I have got instruction from the conducting council, not a single.
What about the other co-accused persons?
He has
He's the owner of the vehicle. He's the owner of the vehicle.
Owner of the vehicle.
What about the others?
Others, though, they are inside the custody because one is the outsider. The driver is the outsider. The present petitioner is the occupant of that vehicle. That is the written in the guideline.
File आइए. File आइए. File आइए. Because the outsider is there.
नहीं, outsider. मुँह चाहिए ना.
आगे आपण बुझू ना थी.
हाँ.
The co-accused is an outsider ना नहीं.
नहीं, हाँ, co-accused is outsider. से driver थिला. मुँह चाहिए. My residence is.
What do you want to?
Fine.
The regular bail will be difficult. Only for that reason.
That reason. नहीं, मुँह चाहिए.
अरे आपण कथा बुझी पाले तो.
बुझिले.
So he will claim parity. It will be difficult for this court to not grant parity to that person.
That's true.
Yes. Item 56.
Obliged.
Item 56.
May please Lordship. The offences are under section 20A of
Yes,
NDPS
sir,
Act and 27(1) of Odisha Forest Act, my lord. The petitioner is not named in FIR, my lord. Subsequently, charge sheet has been submitted against the petitioners and others, my lord. Allegation of cultivation of a cannabis plant.
No, did you earlier approach this court?
Yes, my lord. And this honorable court directed to surrender, my lord. I have, as per your lordship direction, I have filed IA. But in this case, my lord, one Subrat Kumar Karmi,
No, where is that I with in that 2520/2018?
my lord, 922
922 of 19 with.
19.
With HSC.
Lordship, may kindly glance. One
9 ସେଇଥିରେ ଆଇଏ ଫାଇଲ କରିଛନ୍ତି ତ?
Sitra, I have filed for as per your lordship direction and also filed a fresh bail application.
So why did you file a fresh application?
My lord, one Subrat Kumar Karmi.
So here it was said that if you will surrender within 4 weeks, you will be released on bail. Isn't it?
My lord,
In the earlier order.
earlier order not released on bail, my lord. This was of same day,
Who did?
922.
Same day parity.
Same day parity.
Release of co-accused.
Yes, ma'am.
So I can only modify it to say that.
May kindly glance. I have filed.
No, ଶୁଣନ୍ତୁ ଆଜ୍ଞା ତରତର କାହିଁ କରୁଛନ୍ତି? So I will modify it. I will say that in the meantime the co-accused person has been granted bail, so parity may be granted. That's all.
Lordship, may kindly glance your lordship's order.
No, what are you submitting first?
Subrat Kumar Karmi, your lordship released on bail.
Huh.
Previously, bail application was passed in similar order, my lord.
देखिए.
Lordship. I would have cooperated with Aichin direct.
This may not have been brought to the notice of this court. The earlier order may not have been brought to the notice of the court. The second application will not be maintainable. In this case, what has happened in the Subrat Kumar Karmi, probably the previous order has not been referred to at all. So,
Certificate ଦେଇନଥିବେ.
Huh?
Certificate ବି ଦେଇନଥିବେ.
ସେ ଦେଇନି ତ କଣ ହେଇଥିବ? କଣ ହେଇଥିବ? In that Subrat Karmi's case, so the only order that can be passed is that recording all this, that he has been released on bail, co-accused, he stands on the same footing, so parity may be extended.
The co-accused order was देखी थी on surrender released on Hon'Ble also.
See, कौन ହେଇଥିବ?
Released on.
So that will not be proper.
Released on.
All right. IA 1766 of 2024, connected matter ta, है ना? Administrative bill 922 of 2019. This is an application for modification of order dated 26/3/2019, passed in this case. By the said order, liberty was granted to the petitioner to surrender before the court below within 4 weeks and to move for bail. Which will be considered in accordance with the law on the same day. Stop. Learned counsel for the petitioner, however, submits that owing to unavoidable circumstances, the petitioner could not abide by such direction. And in the meantime, the co-accused persons, namely Subrat Kumar Karmi and
Nakula
Kongaro, have been released on bail.
On their surrendering bail.
On their surrendering to custody. Stop. Further, the petitioner stands exactly on the same footing. Stop. He therefore, it is therefore prayed that the order dated 26/3/2019 may be modified to direct the court below to release the petitioner on bail on his surrender. Learned State Counsel fairly submits that the petitioner stands on the same footing as the co-accused persons who have been released on bail. Considering the submissions as above, the prayer for modification is allowed to the extent of granting 2 weeks further time to the petitioner to surrender before the court below.
3 weeks, my lord. 2 weeks.
No, 2 weeks. It is further directed that the court below shall dispose of the bail application on the same day, taking note of the fact that this court has already directed release of the co-accused persons
who stand exactly on the same footing as the petitioner. Yes.
My lord, in the meantime, the case has been transferred to the Court of Learned Special Judge Contamal, my lord. এটা ଆଗରୁ ବହୁତ ଥିଲା ଏବେ କଣ୍ଟାମାଳ
Court in session over the matter କରିଦେବେ ସରିଲା କଥା ଆଉ court in session
କଣ୍ଟାମାଳ
ହେଲା main case ଟା ଯୋଉ first case ଟା
additional session judge କମ special judge କଣ୍ଟାମାଳ
additional session judge କମ special judge କଣ୍ଟାମାଳ ତାକୁ direction
in special NDPS case number 7 of 19
special NDPS case number 7 of 2019 ହେଲା ଆଉ ଯୋଉ first case ଟାକୁ permitted to withdraw.
yes ma'am.
Item 57. May I please? Filed application to restore the TRP CRL and kindly see the page number 11. Undated. The order was passed on dated 5/3/2024 to and also directed to file recusal on 6/3/24. And due to filing of late certified copy obtained after 2 days.
Right.
So that I unable to file the
Considering the submissions, the transfer application is restored to file.
interim order.
Interim order to continue.
Interim order are there.
Interim order will be passed in that case now. Or TRPCL record. Interim order to continue. Yes.
Item number 6.
In this case, petitioner has been opposite party and the opposite party filed a by DB miscellaneous case number 229 of
No, press
2020.
matter.
Again,
Yes. Good.
2023.
No,
which is
Jagatsinghpur
pending
Court of-
before the SDJM Jagatsinghpur.
Yes.
The petitioner and the opposite party both are government employee and the opposite party and each family members and the influenced persons. My lord, and as such the life of the petitioner and in danger at Jagatsinghpur.
How many petitioners are there?
2.
2 or 3? With item 6 though. Item 6 though, Biswajit Mishra. Yes.
For the above reason, the petitioner willing to transfer the
Who
case.
is your senior?
Sir,
Who is your senior?
Rajiv Lachlan.
Rajiv Lochan Patnaik. Let him appear.
Yes.
Please this matter on 17th September.
So item number 8.
May I please, your lordship? In this case, I'm filing a transfer from Senior Division Andhapur to Cuttack, my lord. The petitioner was residing at Cuttack, my lord, and prosecuting his higher studies at Bhubaneswar. And in the meantime, he was filed in CRPC for maintenance at Cuttack, my lord. And the petitioner having no source of income, my lord.
Notice stay. You did? 8th November.
And the lower court proceeding may kindly be stayed. Obliged.
So item number 9.
May I please, your lordship? I am appearing through Virtual Court Kalahandi.
Yes.
Your lordship, the petitioner is the wife who seeks to transfer MAT case number 75 of 2024 pending before the Learned Civil Judge Senior Division Khariar to Learned Family Court Sambalpur, your lordship. She is residing with her ailing widowed mother at Sambalpur, and there is also no direct train or bus communication from Sambalpur to Khariar, which is at a distance of 250 kilometers, your lordship. And she has absolutely no independent income for her survival. And on the other side,
All right, take notice.
much of
Take notice to the opposite party by speed post. Fixing a short returnable date, requisites be filed within 3 working days. Place this matter on 8th November. आइए रे stay कर दे. Stay.
Jubilation, your lordship.
चलेगा. Good.
Weekly list item number 46.
I reserve my
to submit after this. Other points and this question of law.
Very briefly. Reply will be very brief.
After the.
Yes. आज को सॉल्यूशन है.
Other points also.
Yes.
May I please?
Yes.
May see the memorandum of appeal.
You are the defendant.
Respondent number 1.
Respondent number 1 is the defendant.
Yes. Paragraph 2.3.
Respondent number 1 was Gajraj Singh.
Gajraj Singh.
Paragraph?
2.3 of the memo of appeal.
Yes.
As the recorded owner Jaydev Singh. The Jaydev Singh is the recorded owner. In respect of Hamish settlement, Khata number 1, having total area acre 103.83, consisting of 57 plots, meant for exclusive khas possession of eldest son, member Lambardal Kapusdar for maintenance, home farm purposes, and Hamish settlement Khata number, and so meant for the cultivation by all the family members of proprietor Lambardar Kapur were dead by the time of such acquisition. His eldest son Ganeshwar Singh became Lambardar Kapur and inherited Hamish settlement Khata number so and so for himself for maintenance in view of the intermediary duty while his family members and all his mothers jointly possess Hamish settlement Khata. Then paragraph 2.4 and 2.5. These are 2-3 paragraphs I will have to read my lord. The sizable lands out of both Hamish settlement Khata number so and so, certain lands of Hamish settlement Khata number 2 of deceased Jayadev were acquired for the above project. Jayadev is the recorded tenant. His property was acquired under the Hirakud dam project. And there all the family members are obviously the displaced persons. Then the state government took a decision to allot landed property to the ousty villagers being affected by the said project on the basis of due application form, interested displaced and also non-displaced person as measure of required resettlement subject to reclamation by them within the stipulated period. In revenue miss case number 176 of 56-57, the then additional commissioner Hirakud land organization, that is HLO, selected 19 allottees and in another revenue case selected other allottees. The stipulation is such a settlement-wide allotment DC Pota that each allottee have to complete the reclamation within 2 years by the order number under Exhibit 2. Late Ganeshwar Singh was individually allotted DC Pota for reclamation by Exhibit 3 dated 1961. This land was allotted as an individual in response to his application in 1957 for his resettlement through reclamation. As such, prior to the stipulated date, as per Exhibit 3, Ganeshwar Singh himself alone, without any help from brothers, complied the stipulation for settlement, pursuant to the direction made in Exhibit 2-3 within 2 years of individual allotment. Late Ganeshwar Singh approached the HLO authority for verification of the reclaimed land and consequential mutation of the land in his favor HLO. Situated DC Pata allottee and Ganeshwar continued to possess the suit. Then you will also may see the trial court judgment where the genealogy has been given by law.
Yes.
At page, internal page 3. Jayadev Singh is the family, the head of the family. He has the recorded owner. First wife and second wife. Admittedly, after the death of the first wife, he got married for second time and second. The children are disputed between the offspring of those children
Two
of
wives.
the first wife and two wives. The Ganeshwar Singh is the first wife's son and second wife's grandson is the Gajraj and others are there. So, Lordship may see then the Exhibit 4.
as they were, it is admitted in a memorandum of appeal, there were dispute with regard to the allotments. So the government issued a clarification that they're directing the Tahsildar to make an inquiry. So this is the exhibit 4. This has been in paragraph 2.8 of the memo of appeal. It is admitted about because of the dispute with regard to the alert fees.
Yes.
The huge agitation, and so this exhibit 4 was issued. I am directly, Lordship got it?
I don't think I've got it.
Exhibit 4.
No, I've not got it.
Dated होती 20 letter number है 2386 oblique R dated 22nd May 90.
It's online news, right? It's online news. The government notification. Exhibit तो list बिल्कुल नहीं जाऊँगी कौन करी? देखते हैं exhibit. Exhibit 1, 2, 3, 4. बिल्कुल देखा जाऊँगी. इतने जेरोस का तो किन देखी होगी. Copy of orders passed by the additional deputy commissioner. No. This is exhibit 2.
Additional secretary to the government. Raicharan Das from Raicharan Das, additional secretary to government to the revenue divisional committee.
Yes, yes. Yes.
I am directed to invite a reference to the correspondence cited above and to say that in the government letter that cited at within bracket 2 above the procedure to be followed in dealing with cases of the so-called encroachers in the area allotted to the Orissa OPGC on the strength of Bandi Potas granted by the erstwhile Hirakud organization were issued. The procedure to be adopted outside the area allotted to the Orissa OPGC in the matter of grant of tenancy right to be to the displaced persons of Hirakud Dam project would be as follows. The Tahsildar will conduct an inquiry on the spot about the actual possession of the person concerned. During the inquiry, he should ascertain whether the person in actual possession is a genuine oustee or not. The occupation of the legal heirs of the successor of the oustee would be accepted. During this inquiry, the list of oustees or their successor would be drawn up. For this purpose, the Bandi Potas issued by the HLO would be taken into account. In case the person claims to be a genuine oustee but is not able to produce the Bandi Potas, then his status as to whether or not he is an oustee would have to be established during the inquiry by taking evidence, etc. Another list of outsiders in actual occupation would also be drawn up. Then clause D. The oustee would status as oustee is re-established during the inquiry will be treated as the final allottees and land in their favor should be allowed to the extent of allotment in the DC Pota or where the DC Pota is not produced to the extent of 1 standard acre subject to actual occupation. Since the deputy commissioner had next E, deputy has allotted the land and their status is finally re-established during the inquiry, they should be treated as the genuine allottees and mutation proceeding initiated for recording their names in the record of rights. So accordingly, my lord, as per this is supported in paragraph 2.7 and 2.8 of the memorandum of appeal. Why this inquiry proceeding has been initiated, and under this government, as per the government letter, Hirakud land organization, the oustee persons were allotted, and as per this letter, the inquiry proceeding suo moto mutation proceeding has to be conducted by the Tahsildar. Then Tahsildar initiated suo moto proceeding. It's not that at my instance been done. That is at exhibit 5.
Yes.
And as per this exhibit 5, there was a field there was a field inquiry. That field inquiry report is there.
Yes.
Where the genealogy, my lord, has been reflected. Original recorded owner Jaidev Singh and
His descendants are all have been given details. Same as in the judgment, trial court judgment. Accordingly, all of them have been held to be the recorded tenant because of the original recorded tenant is the Jayadev Singh. And this was challenged. This was challenged by the plaintiff. That is in mutation appeal case number 12 of 2003, Exhibit K. And it was dismissed.
All right.
No further revision was filed. Under the settlement, survey settlement, mutation appeal was filed, but thereafter, after this dismissal of the mutation appeal, no revision was filed. On the basis of this, in the plaint, he says the cause of action arises and for which he filed a suit. Lordship may see the plaint copy. Paragraph 11.
Paragraph
11.
Yes.
That the cause of action for this suit arose at village Kirarama within the jurisdiction of this court when mutation of the defendant number 1 to 6 were allowed and settlement of the same was made by the Tahsildar Lakhanpur on 29/5/2000 and when the sub-collector dismissed the mutation appeal number 12 of 2003 on 16/9/2003. And declaration accordingly, a declaration was made in the prayer for declaration, paragraph 12. A declaration to the effect that the defendant number 1 to 6 have no right to be mutated and or settled in respect of Schedule A land, that the plaintiff and pro forma defendant number 7 to 10 have right title and to be settled with settled. Now, what has happened? Well, an interesting point. The plaintiff and pro forma defendant number, there are pro forma defendant number 7 to 10. Plaintiff is there. In this appeal, the plaintiff has been filed jointly by plaintiff and pro forma defendant. No separate appeal have been filed by the pro forma defendant. Though they were the opposite side in the trial court, now they have jointly along with the plaintiff filed the appeal. And if your lordship may see this, as per this admitted fact, because no pleadings with regard to prior petition, nothing has been there in the entire plaint copy. There was a petition earlier for which the Ganesh Singh was separate and by petition by meets and bounds, no pleadings, no whisper, and accordingly no also evidence has been laid. And if your lordship will see at the admitted fact with regard to the cause of action, this is barred by limitation because Article 58 of the Limitation Act, which is a residuary clause for declaration.
3 years.
3 years. 3 years. When the right to sue first accrues. So first accrues is when it is 29/5/2000.
Dismissal of the appeal.
Mutation case is dismissed. Yeah, allow it like. That was the first.
No, he had filed an appeal, no?
Appeal who? The 29 first accrues. There are multiple cause of action, Rohit. It has to be first accrues when it is accrued. So 29/5/2000 is the date of first accrual. So from that date, 3 years has to be taken. So the suit was filed in 2006. So it is barred by limitation.
Yes.
Because the language says when the right to sue first accrues. And to that extent, there is a decision, my lord. I think the citation is also there. It was filed in the court below. That is 2011-9 SCC 126. Three paragraph 21, 22, and 27. May I read it?
Just.
पैराग्राफ नंबर साइटेशन भूल लिखा है करेक्ट अब 20 24 25 30 21 22 and 27.
Yes.
The limited paragraph 21 Limitation Act section 3 every suit instituted after the prescribed period shall be dismissed even though limitation may not have set up as a defense. If the suit is not covered by any specific article, then it would fall within the residuary article. In other words, the residuary article is applicable to every kind of suits not provided in the schedule. Then Article 58, paragraph 22. Article 58 is held to be a residuary article and mentioned when the right to sue first accrues. Then paragraph 27. The word first has been used in between the words sue and accrues. This should mean if a suit is based on multiple cause of action, the period of limitation will begin to run from the date when the right to sue first accrues. To put it differently, successive violation of the right will not deprive to fresh cause, and the suit will be liable to be dismissed if it is beyond the period of limitation counted from the date when the right to sue first accrues. So accordingly, the appellate court has held it to be barred by limitation. The suit filed by the plaintiff appellant is barred by limitation. Appellant number 1.
Yes.
Just a second. Just one more. In the my lord, the family is paying Hindu family, my lord, is presumed to be joined unless it is proved by evidence that is a petition. Here there is no pleadings, my lord. In the plain copy as well as also there is no proof evidence has been laid with regard to that. And the trial court erroneously held there was a petition. Mere separation, my lord, under the Select Act does not amount to petition by metes and bounds. There was a Select Probe case, 29/70, and there was a separate mesh. But that will not say that there was a petition with regard to metes and bounds. The Hindu family presumed to be joined, my lord, that is AR 73 Odisha. And 73 Odisha 85.
That's all right. You don't have to say that. That's a settled question.
And these are my points, ma'am.
You are for respondent defendant number 1.
Yes, ma'am.
Who's for the other defendants?
I am for respondent number 3, 4, 5, 7, 8, and 9.
What about 2?
Two appeals
Sufficient is the?
again. 3, 4, 5, 7, 8, 9. 6 टा खाली नहीं, 2 भी नहीं बोल.
Substitute ହେଇଛନ୍ତି କିଏ?
Your Lordship, kindly have a glance over the plaint and its prayer. The suit admittedly was filed in 2006. Suit is seeking a negative declaration. Your Lordship may kindly see the first declaration they sought for is a negative declaration. And the second positive declaration they sought for, that the plaintiffs and performance defendant number 7 to 10 have right, title, and to be settled with schedule A land, to be settled. And their possession be confirmed, and in alternative, if the court found that the plaintiff and defendant number 7 to 10 have been dispossessed from the schedule land, in the meantime, then recovery of possession of the same from defendant number 1 to 6 be ordered after evicting them there from any other way. Now, Lordship, what is admitted, that is not required to be. And the fact admitted, your Lordship may kindly see that the land which was acquired for the purpose of project is a land belonging to Joydev. Lordship may kindly see paragraph 3. This is 3 of the plan. His sons are separated. There is no whisper about partition. The Hindu family presumed to be joint unless contrary is proved. Now, my lord, I will take your lordships the ROR. The ROR recorded jointly. My lord, the schedule property, your lordship may kindly see schedule A. Unti number 1, plot number 67, 8 acre, corresponding to MS Khata number 113, plot number so, now mutation Khata number 10847. My lord, your lordship, this Unti number 1, though the plaintiff has not filed it, we have exhibited. And it is recorded in favor of Jaydev. It is the, in the, that is Sabik ROR, my lord. It was in the name of Jaydev. All subsequent ROR is joint. Now, my lord, the facts which is further admitted that the plaintiff's, his allegation is that the eldest son of the plaintiff, it was settled in his name that your lordship will find in Ganeshwara Singh, Parapur. He is the eldest son. And your lordship may see genealogy that has also been shown as the eldest son. So now, in the Mityakhara Hindu family, the eldest male member presumed to be Karta unless contrary is proved. So he is the eldest son of Jaydev. It is admitted. He filed an application for getting the benefit of settlement because the land was acquired, and admittedly, all of them are land housing. But there is no dispute that one of the son was the land housing, others are not. The candid admission in the plan that all of them are land housing. My lord friend, shown your lordship, the government order, I will not reiterate it here. It has been clarified in that government order that the Tahsildar will make an inquiry. Here, the Tahsildar has made the inquiry, found that all the legal heirs of Jaydev are in possession and they are all ousted. Directed for preparation of the ROR in their names as per the government executive instruction. It is not a case under the mutation manual, so that mutation order will be carried out. It is a settlement under a special scheme. It is a benevolent scheme. The ousting are to be provided with the land. There is no dispute that Jaydev was the recorded owner. His family was the land ousting. They are entitled for settlement. And the officers under that special scheme, they recognized all the legal heirs of Joydev as oustee and directed for preparation of the settlement ROR in their name. That has been challenged in appeal. Appeal was negative, then the suit was filed. Now the short question which arises for your lordship's consideration. Let us assume that a settlement was made in the name of eldest son, whether it will inure benefit to all or not. That has been decided by the Hon'Ble Court in many decisions. If beneficial settlement made in favor of one will inure benefit to all. That decision I will file for your lordship's consideration along with my notes. That has been taken care by the learned district. He has, while reversing the judgment, he has the learned, your lordship will see that the learned trial court, though he filed the suit for declaration, placed the burden on us. It is your lordship knows burden never shift. It is only onus who can shift from time to time. Burden is always on the plaintiff, who asserts that he has got a right at limit. Here, the orders of the government making beneficial settlement in favor of all the heirs of Joydev. And admittedly, the defendants, including the pro forma defendants and the plaintiff, were the beneficiaries, including the eldest son of Joydev, who is Ganeshwar Singh. The entire gamut of the pleading reveals that since Ganeshwar filed the application, EC Pota was granted in his name alone. The other legal heirs of Ganeshwar, the Joydev, they have got no right. That is in nutshell. In the suit, they have ventilated this. They say that since it was settled, the Pota was granted in favor of Ganeshwar alone. Therefore, the other heirs, that is the children of second wife of Joydev, they have got no right. It is the negative declaration they have sought. Now your lordship knows. Right is always traced from the ancestor in a Hindu family. Unless you say by operations of some law, either there is a division in the family in which this property was exclusively allotted in favor of one of the sons, the court will presume that the family continues to be, Hindu family continues to be joined, and they are under the benefit law. If there is no provision of appeal or revision, it has to be challenged before this Hon'Ble Court, and yes, it can be challenged before the civil court, subject to the year 1940 Privy Council, page 105, Mask and Co. Secretary, if they have failed to follow scrupulously the statutory provisions, then it is amenable in the civil court. Or if fraud has been perpetrated while obtaining the order, then only they can also challenge it before the civil court. Your lordship will read the entirety of the plan. There is no such thing. The allegation is that it has the PC Pota was granted in favor of Ganeshwar. The Tahsildar made an inquiry contrary to the rule recorded in the name of all the heirs of Joydev. If the rules provides that, or the scheme provides that, while preparing the record, the Tahsildar will make a field inquiry, find out whether the person who has been granted PC Pota is in possession or his heirs in possession, he will record. Admittedly, Ganeshwar was not there when the settlement was made. That ROR was prepared. Your lordship will find Ganeshwar was not a party to the suit. It is only the heirs of Ganeshwar and his co-sharers of the litigation, one claiming that it is the exclusive property of Ganeshwar. Others are claiming that since it was the property of Joydev, being the heirs, we are entitled to the benefit under this scheme. Now, I will pause here for a moment. If this authority is under a special scheme, made a settlement in favor of one of the person, then the person aggrieved can ventilate his grievance. Under that scheme, if there is no rule providing appeal or revision, then they can directly challenge before this honorable court in a writ petition. But if your lordship see that the settlement is after the 1962 OGLS Act came into force, because government land can be settled after the 1962 settlement only following the statutory provision under the government land settlement act. Here there is provision for appeal and revision. Your lordship may kindly have a glance. If order has been passed by the Tahsildar, appeal lies to the collector, sub-collector. If the order has been passed by the sub-collector or ADM or collector, it is lies to the Revenue Divisional Commissioner. Your lordship will find the provision of appeal in section 7B. And there is a rule, Miller. Here, without taking resort to the statutory provision, they have come before the civil court. Now, my submission before your honor is twofold. Civil court jurisdiction, in view of the statutory bar under this act, your lordship will find there is a bar. Your lordship will find section 7B. 7B of the OGLS Act. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which any officer or authority is empowered by or under this act to determine, and no injunction shall be granted by any in respect of any action taken or to be taken in exercise of any power conferred by or under this act. My submission before this honorable court. This is a statutory provision. Bar is a statutory bar. The civil court jurisdiction is ousted, as your lordship knows. Every court has got possess 4 types of jurisdiction. Here, because of the bar, the inherent lack of jurisdiction is there in the civil court, which the learned trial court has failed to take cognizance of that bar. And the learned appellate court has considered it on the ground of merit as well as limitation. My learned friend has already placed section 58, article 58, and need not reiterate it. Now, my other submission is admission that Joydev was a Gauntia, Lambordar. Lambordar is an intermediate. All intermediary interests vested with the state government free from all encumbrances because of the provision of the OA Act. Yes. Now, the settlement has to be made under section 6, 7 or 8A, or even under the village BPP Act. Village, that is Lambordar as also called as village public officer.
That was abolished. There was an abolition act also.
There was a
Village Officers Abolition Act or something like that.
आगे प्रथम 64 रे कले तापर abolition. Admit
काउंटे बहुत सब चली गले से.
आज्ञा भोगरा आज्ञा सेगुडा बीपीपी रे आक. Now commission.
So what were you saying? He being an intermediary, after the vesting, what would have happened? You were saying something?
My submission is that under the provisions of OA Act,
Section 8.
under the OA Act, there are 3 notifications under section 3 and 3A. 3 is only all interest which is recorded under 1000. 3A is subsequent notification bringing in full to the vesting of all other intermediary rights. So there is no application made under section 6, 7 or 8A. Therefore, the claim of the plaintiff that because it was recorded in the Sabic record of right, it should have inure benefit to the Ganesh or the eldest son alone, my submission, it will not hold any water. Because the government in its wisdom selected the beneficiary and chosen its wisdom that these are the land ousting and settled the land in their favor. That is no room for adjudication under that. Who is to get how much? They treated everybody as a land house team. Lord, it is admitted in the plaintiff vividly that all of them are land house team, being the heirs of Jayadeva.
So what about the Sabik settlement that you were saying?
Lord, Sabik ROR which was taken away by the government by notification. It lost its force. It is only after the settlement when the ROR was granted, recognizing some as a royal under the royal is declared under the OLR Act. Recognizing some person as a tenant, as your lordship knows, under the OLR Act, under the OT Act are two different category of persons. Tenant under the OT Act is a royal under the OLR Act. Once Tahsildar declares somebody as a royal, it is a creation of new right under a special statute, OLR Act. Therefore, my submission, 67 of OLR Act also creates a bar for adjudication before the civil court, because you are to ventilate your grievance under the provisions of OLR Act before the revenue officer or by appeal under that act or revision under that act. They are provided, section 58 provide appeal, 59 provided for revision. So my submission, once a new right created by the revenue officer recognizing somebody as tenant, that question cannot be determined before the civil court whether the adjudication made by the revenue officer is correct or incorrect. That is only confined to the revenue officer alone. And admittedly, this has been the adjudication by the revenue authority. There is no quarrel over the matter under a scheme prepared by the government for the land house team. And the persons those have been benefited under the scheme, they are paying rent, is one of them. So Ganeshwara is one amongst the heirs of Jayadev. So he cannot challenge the benefit which he accrued, because that will amount to wiping out the very order under which he claims some interest.
Yes.
Therefore, my submission before your lordship here, the learned appeal has vividly considered all the questions involved and recorded a conclusion while setting aside the order of the learned trial court. Now, my submission will confine to my learned friend has placed Article 58. I will only place Section 3 of the Limitation Act. My submission, Section 3 of the Limitation Act cast an obligation on the court. Whether a defense to that effect is taken by the defendants in the written statement or not. It is the obligation of the court that all suits, appeal, revision or application are within the prescribed under that statute. My learned friend placed Article 58 as well as the residuary Article 137. So approaching from any view of the matter, since the Tahsildar recognized all the heirs of Jayadev as the land house team, declared them as royal, my submission, in the year 2000. A suit in 2006, even assuming that the civil court has got some jurisdiction, is barred by law. That's it. Decision that the Janaka favor hella, if the settlement is made in favor of one, it will inure benefit to all. That decision I will file. Mila.
Next week you are not available, Mr. Rahota. So we'll take it up for the week.
The second week of October.
My learned friend has filed some application
For additional
evidence, copy of which has not been solved.
On that day, that is there.
No, you can hand it over. I can argue. There is no harm, because the honorable court can only decide the order for 227 application while considering the option.
Yes, give him a copy. Give him a copy.
Give me copy.
So we'll take it up when you.
Copy with me. Yesterday, junior, nobody was there. That's why I didn't.
No, Aditi. Yeah, when do you want?
Number, page number, it's not done, but it is all correct.
When do you want, Mr. Hota?
Well, the second week.
Second week,
October.
second week तो होगा second
Seventh,
second 7-8 दिन 3 दिन मात्र
In the matter.
First week रे करिए first week रे सरी जाता नॉले vacation पर
ସେ ପୁଣି ଦେବେ ନା ତାଙ୍କର return
ତାହେଲେ
note
21
ଦେବେ ବୋଲେ
ତାରିଖ-
it will be exchanged many things.
हाँ,
21 तारीख commencing 21st October
आगे
it is normally part of matter एते दिन मु
Right.
रखे नहीं
भूल लीजिए
ନାଇଁ, ତାକୁ
But your lordship taken note of every submission.
yes
I've seen.
ମାନେ ଫାର୍ଷ୍ଟ ୱିକ୍ ଅଫ୍ ଅକ୍ଟୋବର ରହୁ ଫାର୍ଷ୍ଟ ୱିକ୍ ଅଫ୍ ଅକ୍ଟୋବର ରହୁ
न सरले पड़े से right you are right
21st ପରେ ଗୋଟେ ଲାଇକ୍ଲିହୁଡ ଆଇ ଡୋଣ୍ଟ ନୋ
कौन जे change ହେଲେ କଣ?
21 ପାର୍ଟ ପରେ ରିଲିଜ ହେଇଯିବ
ହବ।
ଫାର୍ଷ୍ଟ ୱିକ୍ ରେ
ହେଲା I can't do anything about it
ଥାର୍ଡ ରେ ରହିଲେ ଥାର୍ଡ ଫାର୍ଷ୍ଟ ୱିକ୍ ଅକ୍ଟୋବର ଫାର୍ଷ୍ଟ ୱିକ୍ ଅକ୍ଟୋବର
Correct.
ଥାର୍ଡ ହଉ ଡିସିସନ ଟା ବି ଦେବେ କୋଉ ଡିସିସନ ସେ ସାଇଟେସନ ଟା ଦେବେ
no he is suggesting Mr. Udgata is suggesting the third week of September so that if it is completed we can take it as October and we complete it.
ଆଜ୍ଞା no third week of September
Yes.
no wait I'm sorry I am on accommodation till 29th third October
हाँ see 3rd October माने
that is what I'm telling you 3rd October
no 3rd October माने it will come it will be listed in the week commencing
Week
1st
commencing-
October
week commencing first
Act. Like weekly list as well as part of the matter. Heard further arguments in part, list this matter. Yeah, heard arguments in part. At the first time the power.
but week commencing 30th September
Okay.
30th September
List this matter, list this matter in the week commencing 30th September.
I may not be available on it. So I'll take up
সেদিন আর নিয়ে যাবো নি তারপরে দিন নিয়ে যাবো without your presence why should it be taken
Your lordship,
please ask somebody to just make a mention
lordship,
on that day
let me
all right
your lordship may reflect my name because I have already filed power me.
the name of Sri Vivekananda Bhuya be reflected in the court list who appears for the respondents some of the respondents चलो ठीक है
because this is the
Yesterday after yesterday, lordship has done the judgment reserve of creative builders and
हाँ दोनों
we are submitting the notes of some.
yes okay
Pardon to mention, Your Lordship, on behalf of Mr. A.K. Panda. Item number 49, weekly list. Your Lordship, the matter may be taken on any other day, Your Lordship.
नहीं अजिता नोबोली all these matters remaining matters will come in the list will come in the list
May I, my lord? We have taken on item number 39, Your Lordship, we have taken consent from the opposite parties as well. So more time may granted for preparation, let it come 2 weeks after.
Hello, item 51. Item 51. After the vacation.
51
Hello.
no 51 after vacation 2023 matter after vacation
Next week, how list? 51.
Put item 50
objection my lord let it come on
Tal tha if he is objecting let it
Your Lordship, item 49. Your Lordship, item 49 will be taken up next week in the.
it will come all these matters will be adjusted in the next week or the week next
Obliged.
The interim auditor till today ଥିଲା next week ରେ continue sir ଯାହା ଥିବ